दोस्तों नमस्कार। आज हम लोग आर्टिकल 21 ऑफ कॉन्स्टिट्यूशन ऑफ इंडिया के बारे में डिस्कस करने जा रहे हैं। ये आर्टिकल कॉन्स्टिट्यूशन के हार्ट कॉन्स्टिट्यूशन का हार्ट कह सकते हैं। इस आर्टिकल को हम लोग लाइफ और पर्सनल लिबर्टी के नाम से जानते हैं और इस आर्टिकल के ऊपर जितने भी हाई कोर्ट में या सुप्रीम कोर्ट में आर्टिकल 226 में या 32 में जो पटिशन जाते हैं, ज्यादातर उनके बारे में डिस्कस करते हैं। डिटेंशन मैटर भी इसी में आता है और काफी मैटर आते हैं। तो आर्टिकल 21 का मैं आपको जिस्ट बता देता हूँ थोड़ा सा क्या है। आर्टिकल 21 ऑफ कॉन्स्टिट्यूशन ऑफ इंडिया, इसमें लिखा हुआ है प्रोटेक्शन ऑफ लाइफ एंड पर्सनल लिबर्टी। ये इसका टाइटल है। नो पर्सन शैल बी deprived of his life or personal liberty except according to the procedure established by law. Now please note the wording used in this article. क्या बोल रहे हैं वो? नो पर्सन शैल बी, नो पर्सन बोल रहा है, उसमें इंडिया सिटीजन की बात नहीं कर रहा है वो। नो पर्सन शैल बी डिप्राइव्ड ऑफ हिज लाइफ और पर्सनल लिबर्टी। तो एनीथिंग कंसर्निंग विद लाइफ ऑफ पर्सन और anything concerning with personal liberty of a person cannot be curtailed without following the due process of law. Now इसका मतलब यह हुआ कि ये आर्टिकल जो फंडामेंटल राइट है वो सबके लिए है, चाहे वो इंडियन सिटीजन हो या बाहर का सिटीजन हो, सबके लिए है। इसमें दो राइट दिए गए हैं, एक तो राइट ऑफ लाइफ है, दूसरा राइट ऑफ पर्सनल लिबर्टी है। This is, again I say that this is the heart of the constitution. राइट जो इसमें लिखा गया है वो स्पेशली मेंशन करता है दैट नो पर्सन शैल बी डिप्राइव्ड ऑफ लाइफ एंड लिबर्टी एक्सेप्ट एज पर द प्रोसीजर एस्टेब्लिश्ड बाय द लॉ। इसका मतलब यह हुआ कि ये राइट जो है वो स्टेट ही हमको देगा। स्टेट मतलब गवर्नमेंट हमको देगी। गवर्नमेंट, स्टेट मतलब यूनियन गवर्नमेंट होगी या स्टेट गवर्नमेंट होगी, वही हमको इस राइट को देगी। और स्टेट का मतलब यहाँ पर होता है कि गवर्नमेंट के डिपार्टमेंट होंगे, लोकल बॉडी होगी या लेजिस्लेचर होगा, कोई भी होगा, ये सारे के सारे स्टेट के एम्बिट में आ जाते हैं। और अगर कोई प्राइवेट इंडिविजुअल किसी दूसरे इंडिविजुअल के राइट को इन्फ्रिंज करता है तो वो प्राइवेट इंडिविजुअल दूसरे इंडिविजुअल के राइट को इन्फ्रिंज करता है तो आर्टिकल 21 के एम्बिट में नहीं आएगा। उसके लिए the remedy for the victim in this case would be under article 226 or under general law, दूसरे लॉ में जाएगा। जैसे आपने किसी के प्रॉपर्टी के ऊपर इलीगल इंक्रोचमेंट कर लिया तो वो यहाँ पर नहीं आएगा। इसमें सिर्फ जो गवर्नमेंट या गवर्नमेंट के अंडर जो डिपार्टमेंट है और जो लेजिस्लेटर है वही आएंगे। Right to life is not just about the right to survive, but it also entails to live a life with dignity and purposeful meaning. इसका मतलब ये भी होता है। इसका मतलब ये भी होता है आर्टिकल 21 के हिसाब से कि जब आप किसी की लिबर्टी को ले लेते हैं, मतलब सरकार की बात कर रहा हूं, कोई सरकार किसी की पर्सनल लिबर्टी को ले लेती है, तो वो जो पर्सनल लिबर्टी ली गई है वो भी एज पर द प्रोसीजर प्रेस्क्राइब्ड अंडर द लॉ होना चाहिए। इलीगली आप किसी की पर्सनल लिबर्टी को नहीं खींच सकते। अब इसमें कई केसेस ऐसे आए हैं इनके बारे में हम बाद में डिस्कस करेंगे। मैं थोड़ा सा जिस्ट दे देता हूं कि पहला केस जो आर्टिकल 21 में आया था वो 1950 में ए गोपालन का जो केस था। दूसरा इंपॉर्टेंट केस जो अब बाकी बहुत भी आए हैं, लेकिन जो इंपॉर्टेंट केस की बात कर रहा हूं, दूसरा केस है मेनका गांधी का, जिसको हमने लास्ट स्ट्रीम में डिस्कस किया था। तीसरा केस है फ्रांसिस कार्लिन मुलिन वर्सेस यूनियन ऑफ इंडिया, 1981 का केस है। उसमें भी है कि अगर कोई बाहर वाला बंदा है तो उसके भी हमको आर्टिकल 21 में लेके आना है। इसके बाद एक बहुत इंपॉर्टेंट केस 85 का है, ओल्गा टेलिस वाला। ओल्गा टेलिस एक जर्नलिस्ट थी, उन्होंने बीएमसी के खिलाफ जो स्ट्रीट चिल्ड्रन हैं उनके लिए केस डाला था। इसके बाद उन्नी कृष्णन वर्सेस स्टेट ऑफ आंध्र प्रदेश है, 1993 का है, जिसमें राइट टू लाइफ को थोड़ा सा एक्सपेंड किया गया था। अब यहां पर यह है कि आर्टिकल 21 के अंदर सुप्रीम कोर्ट ने जो जजमेंट दिए हैं उनके हिसाब से और जो राइट हैं उनके मैं बारे में बताने देना चाहता हूं। उसमें यह है राइट टू प्राइवेसी। आप किसी की प्राइवेसी को इन्फ्रिंज करेंगे, दैट इज इन्फ्रिंजमेंट ऑफ फंडामेंटल राइट अंडर आर्टिकल 21। बाहर जाने हैं, बाहर किसी को जाना है और नहीं जाने दे रहे हैं तो भी वो आर्टिकल 21 का इन्फ्रिंजमेंट हो जाएगा। राइट टू शेल्टर, बारिश हो रही है, जाड़ा पड़ रहा है, तो जो वहां पर आदमी है उसको शेल्टर का भी राइट होना चाहिए। और किसी को भी आप सॉलिटरी कन्फाइनमेंट में नहीं रख सकते, ये भी एक राइट है इसके हिसाब से। सोशल जस्टिस एंड इकोनॉमिक एम्पावरमेंट का भी उसको राइट है। राइट अगेंस्ट हैंडकफिंग है, आप किसी को हथकड़ी नहीं लगा सकते। आप किसी के एग्जीक्यूशन के, जैसे मान ली कि किसी को फांसी दे गई है, पर्टिकुलर डेट को उसको फांसी देनी है और नहीं दे पा रहे हैं, इसका मतलब ये हुआ कि उसको आप राइट टू लाइफ को कर रहे हैं और वहां पर भी इंफ्रिंजमेंट हो जाता है। अगर कोई आदमी सड़क में पड़ा हुआ है, चोट लग गई, एक्सीडेंट हो गया है, तो उसको डॉक्टर का असिस्टेंट होना चाहिए। डॉक्टर ये नहीं बोल सकता कि नहीं 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 मैं इसका इलाज नहीं करूंगा। पब्लिक हैंगिंग, आप किसी को पोल पे टांग करके लटका नहीं सकते, उसको फांसी नहीं दे सकते। किसी का कल्चरल हेरिटेज है उसका भी प्रोटेक्शन होता है इसके अंदर। पॉल्यूशन फ्री वाटर प्रोवाइड करना स्टेट का काम है, ऐसे ही फ्रेश एयर देना काम है, पॉल्यूटेड एयर नहीं देना चाहिए। बच्चे को पूरा अधिकार है फुल डेवलपमेंट के लिए। हेल्थ और मेडिकल के लिए, एड के लिए भी उसका राइट है पूरा पूरा। इसके अलावा एजुकेशन का उसको राइट है पूरा का पूरा। और जितने भी अंडर ट्रायल हैं उनका प्रोटेक्शन, जैसे कि अभी कुछ दिनों पहले आपने सुना होगा कि अतीक अहमद को और उनके भाई को इलाहाबाद में जब वो मेडिकल के लिए जा रहे थे उनको गोली मार दी, तो वो गलत है, वो उसका राइट का इन्फ्रिंजमेंट हो गया। इसी तरीके से आज लखनऊ के कोर्ट में एक अंडर ट्रायल को गोली मार दी गई, मर गया बेचारा, वो भी एक राइट है जो उसका इन्फ्रिंज हुआ है। एनीवे, तो गुड मॉर्निंग,
नमस्ते सर।
क्या हाल है?
बस ठीक हूँ सर, आपका आशीर्वाद है।
सॉरी, मैं बहुत बिजी था सवेरे, तो इस चक्कर में मैं बना नहीं
नहीं
पाया।
नहीं, मैं वेट
ठीक,
कर रहा था आपका मैसेज का।
हाँ, तो हम आर्टिकल 21 के बारे में डिस्कस कर रहे थे।
जी जी जी, मैं सुन रहा था सर।
इसके अलावा यहाँ पर एक और भी है, जितना मैंने बताया उसके हिसाब से ये है, राइट टू लाइफ एंड सुसाइड। सेक्शन 309
जी
of the
जी
Indian
जी
Penal Code make attempted suicide a criminal offense which is punishable with imprisonment and fine. अब यहाँ पर सुप्रीम कोर्ट ने कुछ वो किया हुआ है, देयर आर मेनी डिबेट्स ऑन वेदर देयर शुड बी this should continue since mental health experts have argued that people are attempted who attempted suicide need adequate counseling and not punishment. The Mental Health Care Act 2017 was passed by the Parliament and the law came into force in 2018. This act is meant to provide for mental health care and services for persons with mental illness and to protect, promote, and fulfill the right of such person during delivery of mental health care and services. ये जो लॉ है 309 वो डिस्क्रिमिनेट करता है। लॉ स्टेट नॉट विथ एनीथिंग कंटेन इन सेक्शन 309 ऑफ इंडियन पेनल कोड एनी पर्सन हु अटेम्प्टेड टू कमिट सुसाइड शैल बी प्रिज्यूम्ड अनलेस प्रूव्ड अदरवाइज टू हैव सीवियर स्ट्रेस एंड शैल नॉट बी ट्राइड एंड पनिश्ड अंडर द सेड एक्ट करके इसको चेंज किया है। इसमें एक वो भी है, वो जो केएम हॉस्पिटल में एक नर्स थी, उनका जो यूथेनेसिया की बात कर रहे थे कि भाई उनको वो कर देना है, इसके बारे में भी है। तो दादा को मैं दे देता हूँ।
जी
दादा
सर।
थोड़ा सा इस बारे में कुछ बोलिए, कौन कौन से हैं, क्या है इम्पोर्टेंस 21 की, थोड़ा बताइए फिर आगे चलते हैं।
हाँ, पैसिव यूथनेसिया बोल रहे हैं,
हाँ
तो उसमें कॉमन कॉज वर्सेस यूनियन ऑफ इंडिया।
नहीं नहीं, आप 21 के बारे में बोलिए यूथेनेसिया। मैं तो ऐसे ही एक ओवरव्यू दे रहा था, पूरा पूरा मतलब इंट्रोडक्शन
जी
टाइप दे
जी
रहा
जी।
था। आप 21 के बारे में थोड़ा बोलिए, क्या है 21 इज वेरी
तो
इंपॉर्टेंट।
21 तो declares that no person shall be deprived of his life or personal liberty except according to procedure established by law, which is
हम्म
available to both citizens and non-citizens। तो दोनों के लिए है। तो
हम्म
उसमें हम लोग आगे डिस्कस किए थे गोपालन केस, खड़क सिंह, मानेका गांधी।
हम्म
मानेका गांधी के बारे में तो इलाबोरेटली बोले हैं, ओल्गा टेलिस का बता ही दिए अभी।
हम्म
आर राजगोपाल एक है, ऑटो शंकर केस, इसमें सिटीजन का राइट है टू सेफ गार्ड द प्राइवेसी ऑफ हिज ओन पर्सन, हिज फैमिली, मैरिज, प्रोक्रिएशन, मदरहुड, चाइल्ड बेयरिंग, एजुकेशन, ये सब है। And none can publish anything concerning the above matters without the consent of the person, whether truthful or otherwise, whether
हम्म
laudatory or critical।
हम्म
और एक केस है सर इम्पोर्टेंट, मोहिनी जैन, ये वर्सेस स्टेट ऑफ कर्नाटका, 1992 एआईआर 1992 सुप्रीम कोर्ट 1858। इसमें सुप्रीम कोर्ट बोल रहा है कि एवरी सिटीजन हैज द राइट टू एजुकेशन। ये आप बोल रहे हैं सर,
हम्म
education is concomitant to fundamental rights. So every person should have the right to education, including the other freedoms like freedom of speech and expression, and to live with individual dignity।
हम्म
और एक रथिनम केस वर्सेस यूनियन ऑफ इंडिया है, उसमें जो आप बोले थे, सुसाइड इज अ penal offense but includes the right to live। Article
हम्म
21 includes the right to live, but again, the
with
right to die has been given in that particular शानभाग की क्या नाम था ना, शानभाग, उस
हम्म
नर्स का। तो
शान
उस
बाग वाला।
पर्टिकुलर केस में, हाँ हाँ, ये बहुत इंपॉर्टेंट केस है। इसमें वो राइट दिया गया है कि पर्सन ऑल्सो हैज द राइट टू die with dignity if the person slips into, say, irreversible coma and
हम्म
becomes a vegetative, the body is a vegetative state, cannot be revived at all। क्योंकि जिंदगी भर तो वो मतलब हम लोग क्या बोलते हैं उसको, ये इंस्ट्रूमेंट्स के ऊपर, मेडिकल इंस्ट्रूमेंट्स के ऊपर उनको जिंदा रख के तो कोई फायदा नहीं है, बिकॉज द ब्रेन इज ऑलमोस्ट डेड, ऑलमोस्ट।
हम्म
जबरदस्ती मतलब आर्टिफिशियली ऑक्सीजन देकर और भी जो जो प्रक्रियाएं हैं मेडिकल, उसको
हम्म
देकर मतलब किसी को जिंदा रखना इज नॉट प्रॉपर अकॉर्डिंग टू द कोर्ट। तो
हम्म
ये केस, पर्टिकुलर केस में जब अप्लाई किया गया था, एप्लीकेशन डाला गया था कोर्ट में, तो कोर्ट राइटली सेड दैट शी हैज द राइट टू डाई, बट this is only in a particular case and in a particular set of facts and circumstances. ऐसा नहीं कि कोई भी मरना चाहे और उसको मरने दिया जाए, तो दैट इज नॉट देयर. तो आप तो सर कवर तो सब कर ही दिए हैं ऑलमोस्ट. मैं सुन रहा था, मेरा 2 मिनट आने में लेट हो गया, लेकिन मैं बाहर बैक स्टेज था. आप तो पूरा कवर कर ही दिए फॉर द जनरल पब्लिक. तो और क्या बताऊं मैं सर, आप तो पूरा ही कवर कर दिए ऑलमोस्ट.
उल्गा टिलिस भी कवर कर दिया हम लोगों ने इसमें.
हाँ 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 हाँ.
ये तो काफी, मतलब इसमें तो जितना बोलो उतना कम है भाई, क्या बताऊं मैं
नहीं
तो.
नहीं, तो इलेबोरेटली बोलेंगे तो पूरा किताब बन जाएगा इसका. इतना ज्यादा मतलब डेवलपमेंट हुआ है इस पर्टिकुलर आर्टिकल को लेकर.
मेरा
कोर्ट
तो ये
हैज
फील्ड है, मैं तो सुप्रीम हाई कोर्ट में
given
यही
a
करता था.
plethora of judgments, over time, which shows that the law is progressive.
विशाखा भी इसी में आता है ना.
जी जी जी, विशाखा में है. विशाखा में ये है कि द राइट टू एक्सप्लॉयटेशन ऑफ women in workplace. So now it has become compulsory both in private and government organizations to have a particular body in which there will be a set of women also in the body, so that women are not exploited in the workplace. तो कंप्लेंट बॉक्स रहता है बाकायदा. यू कैन ऑल्सो सेंड अ मेल, so immediately the committee will take up the matter and decide. It's been made compulsory by the government that the government should get a report from the committee regarding the findings after an exhaustive inquiry.
हम लोगों ने लॉ में अपना जब पढ़ा था तो उसमें एमसी मेहता का नाम बहुत पढ़ा था ना, एनवायरमेंटलिस्ट
जी
था ना
जी
वो.
जी जी जी
तो
जी.
वो भी तो राइट टू क्लीन एयर एंड ऑल, उसके बारे में भी बात
हाँ,
करते हैं.
वो सब है. राइट टू क्लीन एयर बिल्कुल है. आप तो ये कवर कर दिए सर. आप तो बोल रहे थे उसके विषय में. बट ऑल सड एंड डन, अब दिल्ली का ही हाल देखिए. देयर इज नो क्लीन एयर इन दिल्ली. देयर इज नो क्लीन एयर इन कलकत्ता.
इवन मेरे ख्याल में राइट टू नो भी है ना कहीं पर, कि मतलब.
राइट टू नो आपका आरटीआई में है. वॉट एवर इज इन दी, if there is no conflict of, I mean, interest with a particular party, or if I want some information which is not secret, or which may I mean sort of create some problem with the security and safety of the state, that will not be allowed. लेकिन आरटीआई में तो ये सब provisions है. We can always apply under आरटीआई, and that comes from the right to know. तो ये पहले तो इंडिया में नहीं था, लेकिन लागू होने के बाद काफी फायदा हुआ है उसमें. एक एग्जांपल दे रहा हूँ सर. एक पर्टिकुलर आदमी का सैलरी पता नहीं चल रहा था. सो आई रोट टू द पब्लिक इंफॉर्मेशन ऑफिसर. तो within 10 to 15 days I got a reply with this salary slip कि हाँ, ये आदमी यहाँ काम कर रहा है, इसका ये सैलरी है. तो उसमें वो 10 रुपए का पोस्टल ऑर्डर डालना पड़ता है इफ यू वांट एडिशनल इंफॉर्मेशन. तो उसके लिए उन लोग बाद में बोलते हैं कि जस्ट पे समथिंग फॉर जेरोक्स चार्जेस एंड अदर थिंग्स. अच्छा, ये 30 दिन के अंदर पीआईओ को देना है. यदि वो नहीं देता है तो देयर इज एन appellate authority also above the public information officer, and that public information officer is particularly designated in every department of the government. And even in government undertakings and in institutions, educational institutions also, this provision has been given. तो कोई कॉलेज में मान लीजिए कोई पढ़ा रहा है, उसके विषय में आप जानना चाह रहे हैं. if if it is found that the information that I'm asking for about the person will not affect the running of the college or go against the rules of the university and other things, they will immediately inform me that no, this information can be given, this cannot be given. ये तो सर आप भी तो सब जानते ही हैं इस विषय में. मैं क्या बताऊं सर. तो राइट टू नो में ये आ ही जाता है आरटीआई, राइट टू इंफॉर्मेशन एक्ट. और सर?
चलो मैं आपको एक आर्टिकल पढ़ने को बोलता हूँ, पढ़िए, बहुत
जी सर।
एग्जॉस्टिव आर्टिकल है। अगर आज खत्म
नो
नहीं होता तो
प्रॉब्लम
आर्टिकल
एट ऑल
21
सर।
को हम बाद में फिर से करेंगे। इसको थोड़ा देखें क्या है ये।
तो एज यू राइटली सेड सर, ये ऐसा है कि जितना भी बोला जाए इट्स नेवर एंडिंग ऑलमोस्ट।
यस, दिख रहा है?
बिल्कुल सर, एकदम साफ।
एक मिनट, उसके ऊपर जाता हूँ मैं।
कि पंजाब यूनिवर्सिटी की है,
हम्म।
रिया जैन, शी हैज रिटन द आर्टिकल। So it begins with the article itself. No person shall be deprived of his life or personal liberty except according to a procedure established by law. अब इसमें फ्रांसिस कोरली मालिन versus the administrator, उसमें जस्टिस पी भगवती has said that Article 21 embodies a constitutional value of supreme importance in a democratic society. उसके बाद जस्टिस आयर has characterized Article 21 as the procedural magna carta protective of life and liberty. So this article is very important. Article 21 is at the heart of the Constitution. It is the most organic and progressive provision in a living constitution. Article 21 can only be claimed when a person is deprived of his life or personal liberty by the state as defined in Article 12. Thus, violation of the right by private individuals is not within the purview of Article 21. So, we can hold the state accountable for this.
हाँ, नहीं नहीं, ये सारे का सारे आर्टिकल 121 इज ओनली फॉर स्टेट्स ना।
यही बोल रहा हूँ सर, यही मैं
प्राइवेट
बोल रहा हूँ,
पर्सन का नहीं है,
इसलिए ये
प्राइवेट पर्सन का चक्कर है ही नहीं इसमें।
तो अलग
स्टेट
अलग कानून है, उसके लिए एकदम अलग कानून है।
वन पार्टी हैज टू बी गवर्नमेंट, कुछ भी हो।
डेफिनेटली, डेफिनेटली। Then Article 21 secures two rights: right to life and
क्या हुआ?
नीचे कुछ होगा सर,
जस्ट अ मिनट,
नो प्रॉब्लम एट ऑल।
एक मिनट। हाँ।
And right to personal liberty. It prohibits the deprivation of the above rights except according to a procedure established by law. It corresponds to the Magna Carta of 1215, the 15 and the 15th Amendment to the American Constitution. Article 40, सब आर्टिकल 4 ऑफ आयरलैंड होगा, ये आयर लिखा हुआ है, आयरलैंड होगा 1937, एंड आर्टिकल 31 of the Constitution of Japan 1946. तो इसमें से भी ये लिया गया है। It
हम्म।
is also fundamental to democracy as it extends to natural persons and not just citizens. मतलब सिटीजन आप बोले हैं, ये पॉइंट आप कवर किए हैं। It is available to every person, citizen or non-citizen alike. Even a foreigner can have a right to this. So it does not deprive the right of a foreigner under this article. It, however, does not entitle a foreigner to write or decide or settle in India as mentioned in Article 19(1)(e).
हम्म।
ये एक मतलब उनका वो रिस्ट्रिक्शन है, बाकी तो सब फॉरेनर को भी ये आर्टिकल का फायदा मिल सकता है। दिस आर्टिकल इज एन ऑल टेल द फर्स्ट पार्ट। अच्छा, फिर आते हैं, एवरीवन हैज द राइट टू लाइफ, लिबर्टी एंड द सिक्योरिटी ऑफ अ पर्सन। The right to life is undoubtedly the most fundamental of all rights. All other rights add quality to the life in question and depend on the pre-existence of life itself for their operation. Human rights can only attach to, क्या बोल रहा है आगे देखते, to living beings. One might expect the right to life itself to be in some sense primary, since none of the other rights would have any value or utility without it. There would have been no fundamental rights worth mentioning if Article 21 had been interpreted in its original sense. So then we will go back to the other sessions which we had earlier. Earlier, there was a very narrow view of Article 21 by the courts. But gradually, with the passage of time, the court started expanding the scope of this article to cover all these things. Life in Article 21 is not mainly physical act of breathing, but also connotes mere or does not connote mere animal existence or continued drudgery through life. It has a much wider, including the right, wider meaning, including the right to live with human dignity. तो टू लिव विथ ह्यूमन डिग्निटी में सर वो भी कवर हो जाता है, राइट टू आई मीन डाई ऑल्सो, डाई विथ
हम्म,
डिग्निटी.
हम्म.
If a person cannot live with human dignity, he definitely has the right to die. तो उसमें वो आ जाएगा फिर वो पर्टिकुलर केस जो हम लोग बोल रहे थे.
हम्म.
राइट टू लाइवलीहुड, राइट टू हेल्थ, राइट टू पॉल्यूशन फ्री एयर एटसेट्रा, ये सब तो आप बोल दिए सर. Right to life is fundamental to our very existence, without which we cannot live as human beings, and include all those aspects of life which makes man's life meaningful, complete, and worth living. It is the only article in the Constitution that has received the broadest possible interpretation. Thus, the bare necessities, minimum and basic requirements for a person, from the core concept of the right to life, is found here. ये खड़क
My
सिंह
humble request to
वर्सेस
all
स्टेट
viewers
ऑफ
is
यूपी.
to please note down the judgments. That first judgment is Khadak Singh versus State of Uttar Pradesh.
खड़क सिंह.
Here it is mentioned by the term life.
By the term life, as here used, something more is meant than mere animal existence. The inhibition against its deprivation extends to all those limbs and faculties by which life is enjoyed. That means all the ways and means by which we enjoy life. The provision equally prohibits the mutilation of the body by amputation of an armored leg, or the pulling out of an eye, or the destruction of any other organ of the body through which the soul communicates with the outer world.
Just a minute.
मतलब जी
Viewers,
सर.
please note if you want the judgment, Miss copy of Supreme Court or whatever it is, then please write to me on my email, or you
जी सर.
put that request in the chat. I will try to provide the judgment like Khadak Singh versus State of Uttar Pradesh.
फिर आया सुनील बत्रा वर्सेस दिल्ली एडमिनिस्ट्रेशन. इसमें द सुप्रीम कोर्ट अप्रूव्ड द अबव ऑब्जर्वेशन, मतलब खड़क सिंह. इट हेल्ड दैट द राइट टू लाइफ इंक्लूड्स द राइट टू लीड अ हेल्दी लाइफ, to enjoy all facilities of the human body in the prime conditions. It would even include the right to protect a person's tradition, culture, heritage, and all that gives meaning to a man's life. In addition, it consists of the right to live and sleep in peace, and the right to repose and health.
Now I don't want to
ये
extend this, but right to sleep लिखा हुआ है. ये
कहाँ,
actually तो 5 बार की नमाज जो पढ़ते हैं उससे क्या
वही
होता
वही बोलने जा रहा था मैं. दैट इज इरिटेटिंग. नमाज, फिर processions, noise created by other people by using loudspeakers in many ways. So that give, does not give us the protection afforded by Article 21.
है. ये
राइट टू
मेरे
लिव विथ
को
ह्यूमन डिग्निटी. अभी मानेका गांधी वर्सेस यूनियन ऑफ इंडिया पे आ गए. This the Supreme Court in this judgment gave a new dimension to Article 21. The court held that the right to live is not merely a physical right, but includes within its ambit the right to live with human dignity. Elaborating the same view, the court in Francis Corelli versus Union Territory of Delhi observed the right to life.
just a minute. कौन सा है
नो
ये?
प्रॉब्लम एट ऑल. ये वो बाकी मतलब जितना रेफरेंस लिया गया, केसेस अपेयरिंग अंडर दिस आर्टिकल, पूरा लिस्ट दे
This
दिया.
is third कब नहीं, मैं ये
हाँ,
सोच
थर्ड
थर्ड
वाला है.
थर्ड में क्या है? थर्ड इज
हम्म.
व्हाट? थर्ड इज
ये
1978 AIR.
हाँ, ऑल इंडिया रिपोर्टर 597 1978, सुप्रीम कोर्ट रिपोर्टेड वॉल्यूम 2, पेज 621.
ये बताना चाह रहा था मैं इसमें इसलिए.
हाँ, ये पीपल शुड अंडरस्टैंड कि कैसे जजमेंट्स मतलब कंपाइल किए जाते हैं और कैसे उसको निकाला जाता है. यू आर
हाँ.
राइट सर. The right to live includes the right to live with human dignity and all that goes along with it, namely the bare necessities of life, such as adequate nutrition, clothing and shelter over the head, and facilities for reading, writing, and expressing oneself in diverse forms. freely moving about and mixing and mingling with fellow human beings, and must include the right to basic necessities of life and also the right to carry out functions and activities as constitute the bare minimum expression of human self. मतलब घूमना फिरना बाहर अपना एसोसिएट करना सब चीज इसमें इंक्लूडेड है. Another broad formation of life to dignity is found in Bandhua Mukti Morcha versus Union of India. Characterizing Article 21 as the heart of fundamental rights, the court gave it an expanded interpretation. Justice Bhagwati observed, it is the fundamental right of everyone in this country to
छोड़ दो,
live with
इसका पूरा
human.
पढ़ने की जरूरत नहीं है, छोड़ दो,
Yeah,
यहाँ
उसमें
पढ़ो.
सब directive principles सब. These are the minimum requirements which must exist in order to enable a person to live with human dignity, and no state, neither the central government nor any state government, has the right to take any action which will deprive a person of the enjoyment of these basic essentials. फिर पीपल्स यूनियन फॉर डेमोक्रेटिक राइट्स वर्सेस यूनियन ऑफ इंडिया, इसमें पेमेंट के बारे में है सर, ये भी थोड़ा बता दें हम लोग.
1982 है, हाँ.
हाँ हाँ हाँ. तो इसमें पेमेंट के बारे में बताया गया है. It's to do with basic human dignity to workers who are employed by a contractor. Here it was held that the non-implementation by private contractors engaged for constructing a building for holding Asian Games in Delhi and non-enforcement of these laws by the state authorities of the provisions of these laws was held to be violative of the fundamental rights of workers to live with human dignity contained in Article 21. तो ये कॉन्ट्रैक्टर्स एक्सप्लॉइट करते हैं ना, मतलब 2 घंटा छुट्टी देते होंगे और लगातार काम करवाते होंगे बिना खाने का, बिना मतलब फैसिलिटीज का गर्मी में. तो दिस इज इनह्यूमन. So that particular judgment was passed in that context. In Chandra Raja Kumar versus Police Commission of Hyderabad, it has been held that the right to life includes the right to live with human dignity and decency. Therefore, keeping a beauty contest is repugnant to the dignity or decency of women and offends Article 21 of the Constitution only. Yeah, this is important. Only if the same is grossly indecent, scurrilous, obscene, or intended for blackmailing. मतलब कोई ब्यूटी कॉन्टेस्ट हो रहा है तो हम लोग कोर्ट तो नहीं जा सकते हैं कि विल स्टॉप इट. तो इसमें एक दिया हुआ ओनली इफ द सेम इज ग्रोसली इंडिसेंट, scurrilous, obscene, or intended for blackmailing. Therefore, the government is empowered to prohibit the contest as objectionable performance under Section 3 of the Andhra Pradesh Objectionable Performances Prohibition Act 1956. Similar laws are there in other states also, but again subject to reasonable restrictions. In state of Maharashtra versus Chandrabhan, the court struck down a provision of Bombay Civil Service Rules 1959. This provision provided for payment only of a nominal subsistence allowance of ₹1 per month to a suspended government servant upon his conviction during the pendency of his appeal as unconstitutional on the ground that it was violative of Article 21 of the Constitution. सर इस विषय में आप और बढ़िया बोल पाएंगे. अब आजकल सस्पेंड करने से सब्सिस्टेंस अलाउंस 50% दिया जाता है ना सर. 50%.
50% दिया जाता है और 3 महीने तक मैक्सिमम रहता है. उसके बाद में फिर उसको
जी
रिव्यू
जी उसके बाद फिर रिव्यू किया जाता है उसको.
एंड देन
अच्छा, पैरेलली यदि
बाद में तो रिव्यू भी नहीं होता है.
जी पैरेलली यदि क्रिमिनल केस चले तो that has got nothing to do with the disciplinary proceeding because both are on a separate platform. इससे अधिक और कुछ बताऊं सर. मान लीजिए बरी हो जाता कोई आदमी क्रिमिनल प्रोसीडिंग में, तो that plea also cannot be taken in the disciplinary proceeding unless he is found not guilty.
बट उसमें कंडीशन ये है, वो जो पाल अंचली में बोलता है ना, वहां पर बोलता है कि इफ द ट्रू चार्जेस आर ऑफ द सेम सेट एंड द विटनेसेस आर सेम एंड ऑल द
हाँ देन नहीं, उसमें सर स्टे मिल जाता है, एक स्टे मिल जाता है फ्रॉम द कोर्ट, क्योंकि इफ द डिफेंस इज डिस्क्लोज्ड इन द इनिशियल स्टेज, अब दोनों पैरेलली चल रहा है So I will not disclose my defense in the preliminary stage. Na? That will affect my what should outcome in the criminal proceeding or in the disciplinary proceeding, whichever the case may be earlier. जैसा जो जल्दी आएगा उसमें.
दूसरा एक फंडा ये भी है कि जहां पर क्रिमिनल केसेस है वहां पर स्ट्रिक्ट
प्रूफ,
इंटरप्रिटेशन ऑफ
स्ट्रिक्ट
लॉ होता है
प्रूफ.
ना.
हाँ हाँ, स्ट्रिक्ट प्रूफ. इसमें
तो
उतना
अगर
स्ट्रिक्ट
वहां
प्रूफ
पर आप
नहीं है.
प्रूव नहीं कर पाए तो फिर प्रिपॉर्डेंस ऑफ प्रोबेबिलिटी में कहाँ प्रूव कर
तो
पाओगे.
हाँ बिल्कुल सर, बिल्कुल ये एग्जैक्टली सर, एकदम सही चीज आप बताए. राइट अगेंस्ट सेक्सुअल हैरेसमेंट एट वर्क प्लेस. हाँ उस वही दिया गया वो विशाखा जजमेंट इज वेरी इंपॉर्टेंट हियर. नीचे दिया हुआ है सेक्सुअल हैरेसमेंट ऑफ वुमेन. ये जस्टिस वर्मा
Students,
पास
please
किए थे,
note,
द फेमस.
Visakha is a judgment which always comes in whenever you deal with constitutional paper. Visakha is
विल ऑलवेज
going to
कम.
come. Visakha Maneka Gandhi आता ही आता है.
इन दिस
तो ये
केस
बात तो जो
द
देखेंगे
सुप्रीम कोर्ट
वीडियो जो
डिक्लेयर्ड.
लास्ट मिनट होंगे कम से कम उनके लिए बता देते कि विशाखा को तो आप बाई हार्ट कर लो भाई.
The Supreme Court declared sexual harassment at the workplace to violate the right to equality, life, and liberty. Therefore, a violation of Articles 14, 15, and 21 of the Constitution. देखिए इसमें पूरा सीरीज पूरा ये कर रहा है 14, 15, 21 तक. In this case, in the absence of a relevant law against sexual harassment, the Supreme Court laid down the following guidelines to ensure gender parity in the workplace. That meant that all employees or persons in charge of the workplace, whether in public or private, should take appropriate steps to prevent sexual harassment. Express इसमें पूरा
ये
दिया
ये
हुआ है. What?
ये 6 कंडीशन है जिसको सुप्रीम
जी जी
कोर्ट ने बनाया था और हर एक गवर्नमेंट डिपार्टमेंट को इसको फॉलो करना जरूरी है, फॉलो करते भी है. ठीक है, इसको आगे चल जाते हैं, छोड़ दो.
जी सर. फिर ये अपैरल एक्सपोर्ट प्रमोशन काउंसिल वर्सेस ए.के. चोपड़ा. इसमें विशाखा रूलिंग
इसको
कोई
फॉलो किया.
रिएटरेट करके सेम चीज, ऑलमोस्ट सेम चीज बताया.
हाँ. In our opinion, the content of the fundamental right guaranteed in the Constitution are
Guaranteed
of sufficient
constitution
amplitude to encompass
to
all facets of
encompass.
gender equality, including prevention of sexual harassment and abuse, and the court are under a constitutional obligation to protect and preserve these fundamental rights. The sexual harassment of a female at the place of work is incompatible
Incompatible
with
with
dignity
the
and
dignity
honor of
and
a female and need to be eliminated.
eliminated. अब ये रेप का ये एक क्वेश्चन आ रहा है इसमें. ये इसमें बोधिसत्व गौतम वर्सेस शुभ्रा चक्रवर्ती. इस केस में सुप्रीम कोर्ट ऑब्जर्व रेप इज दस नॉट ओनली अ क्राइम अगेंस्ट द पर्सन ऑफ अ वुमन हु इज द विक्टिम, it is a crime against the entire society. It destroys the entire psychology of a woman and pushes her into deep emotional crisis. It is only by a sheer willpower that she rehabilitates herself in the society, which, on coming to know of the rape, looks down upon her in derision and contempt. This is correct. आज भी ये चीज है. Rape is therefore the most hated crime. It is a crime against basic human rights and is also violative of the victim's most cherished of the fundamental rights, namely the right to life with human dignity contained in Article 21. Reputation. This is very important also. So in D. Marion versus Minnie Davis, और फिर किरण बेदी वर्सेस कमिटी ऑफ इंक्वायरी. इसमें वही मतलब अपना वो आईपीएस साहब वो थे ना. आई डोंट वांट टू टेक हिज नेम. गुड रेप्यूटेशन वाज ऑलमोस्ट. हाँ
वो नहीं थे, वो रूपल बजाज है, वो अलग है. वो
अच्छा वो अलग है. ये इसमें कौन सा था सर?
हैं?
ये किरण बेदी वाला कौन सा था सर? रूपन देओल बजाज वर्सेस. हाँ
किरण
वो
बेदी
वाला.
वर्सेस
सॉरी
कमिटी
सॉरी.
ऑफ इंक्वायरी में बोला है. उसको किरण बेदी को वो कर रहे थे ना ये लोग. उसको जब ये दिल्ली में थी ना, वहां पर तो कुछ गड़बड़ कर रहे थे ये जो कांग्रेसी लोग थे. इसके लिए कुछ हुआ था. पढ़ो तो मालूम पड़ेगा.
अच्छा. गुड रेप्यूटेशन was an element of personal security and was protected by the Constitution, equally with the right to enjoyment of life, liberty, and property. The court affirmed that the right to enjoyment of life, liberty, and property and private reputation was of ancient origin and was necessary to human society. Then the state of Maharashtra versus public concern of government governance trust. The court held that good reputation was an element of personal security and was protected by the constitution equally with the right to enjoy life, liberty and property.
ये पब्लिक कंसर्न ऑफ गवर्नेंस ट्रस्ट ने मुझे अवार्ड दिया था नवलीन कुमार 2004 में।
जी
ये
जी It has been held that the right equally covers a person's reputation during and after his death. Thus, any wrong action of the state or agencies that sullies the reputation of a virtuous person would undoubtedly come under the scope of Article 21, even after the death of the person.
तो राहुल गांधी फिर रोज क्यों वीर सावरकर को गाली देता रहता है?
सर कोई एक्शन ले नहीं रहा तो क्या किया जाए? Somebody must file a case then.
तो उसके जो परिवार वाले क्या कर रहे हैं? दे शुड फाइल ना।
Definitely, sir. State of UP versus Mohammad Naim succinctly laid down the following tests while dealing with the question of expansion of disgracing remarks against a person or authority whose conduct comes in consideration before a court of law. These are whether the party whose conduct is in question is before the court or has an opportunity of explaining or defending himself, whether there is evidence on record bearing on that conduct justifying the remarks, whether it is necessary for the decision of the case as an integral part thereof to animadvert animadvert on that conduct. Animadvert on that conduct. It has also been recognized that judicial pronouncements must be judicial. It should not normally depart from sobriety, moderation, and reserve. तो फिर
गाली
इसमें वो नुपुर शर्मा वाले में भी बोलना चाहिए. Why should the court, I mean, pass off the cuff remarks, though it was not recorded in the order. यदि order में record होता तो ये expunging के लिए it was a fit case. But the court should refrain from stepping beyond the petition. In case of Bihar versus Lal Krishna Advani, a two-member commission got appointed to inquire into the communal disturbances in the Bhagalpur district on 24th of October 1989. The commission made certain remarks in the report which impinged upon the respondent's reputation as a public man without allowing him to be heard. अच्छा, इसमें भी ऑडियो अल्ट्रम पार्टम आ रहा है. The apex court ruled that it was simply clear that one was entitled to have and preserve one's reputation and one also had the right to protect it. The court further said that if any authority, in the discharge of its duties fastened upon it under the law, traverses into the realm of personal reputation adversely affecting that person, it must provide a chance to have that person say in the matter. Finally, the court observed that the principle of natural justice made it incumbent upon the authority to allow that person before any comment was made or opinion was expressed, which would be likely to affect the person prejudicially. Right to livelihood. तो इसमें रे संतराम केस. This was before the Maneka Gandhi case. The Supreme Court ruled that the right to livelihood would fall within the expression of life in Article 21. The right to livelihood would be included in the freedom enumerated in Article 19 or even in Article 16 in a limited sense. But the language of Article 21 cannot be pressed into aid of the argument that the word life in Article 21 includes livelihood also. But then the view changed. The definition of word life in Article 21 was read broadly. The court in Board of Trustees of the Port of Bombay versus Dilip Kumar Raghavendranath Nadkarni came to hold that the right to life guaranteed by Article 21 included the right to livelihood. Life and livelihood. फिर ओल्गा टेलिस का भी यहाँ रेफरेंस फिर दिया गया. No person can live without the means of living. That is the means of livelihood. The sweep of the right to life conferred by Article 21 is wide and far reaching. It does not mean merely that life cannot be extinguished or taken away, as for example, by the imposition and execution of death sentence, except according to procedure established by law. That is but one aspect of the right to life. An equally important facet of the right to life is the right to livelihood, because no person can live without the means of livelihood.
जिंदा कैसे रहेगा?
हाँ,
without means.
definitely without the means to earn a livelihood. If the right to livelihood is not treated as part and parcel of the Constitution, right to life, the easiest way of depriving a person of his right to life would be to deprive him of his means of livelihood to the point of abrogation. Then, in the case, the Supreme Court observed the state may not, by affirmative action, be compelled to provide. अच्छा यहाँ देखिए how it starts. The state may not, by affirmative action, be compelled to provide adequate means of livelihood or work to citizens, but any person who is deprived of his right to livelihood except according to just and fair procedure established by law can challenge the deprivation as offending the right to life conferred in Article 21. तो इसमें ये बोलना चाह रहा है कि कोई गारंटी सबको तो नहीं दे सकता टू एवरी सिटीजन कि मैं काम दूंगा, लेकिन जो काम कर रहा है उसको यदि डिप्राइव किया जाए, बिकॉज स्टेट कैनॉट टेक केयर ऑफ एवरीबडी, तो उसका मिनिमम मीन्स ऑफ ensuring his livelihood, if that is taken away, then there is no question of his right to life also. यही बोलना चाह रहा है ना सर. Emphasizing upon the close relationship of life and livelihood, the court stated that which alone makes it impossible to live, leave aside what makes life livable, must be deemed to be an integral part of the right to life. Deprive a person from his right to livelihood, and you shall have deprived him of his life.
Yes.
मतलब livelihood छीन लेने से life goes away. फिर डीटीसी वर्सेस डीटीसी मजदूर कांग्रेस. Acha, yeah, the court was hearing a matter where an employee was laid off by issuing a notice without any reason. Court held that the same was utterly arbitrary and violative of Article 21. But simply notice देकर without hearing him or holding
आ
any
गया, ये
proceeding.
पालनधनी आ गया जो मैं बता रहा था, पालनधनी आ गया यहाँ पे देखो.
G. M. Paul Anthony versus Bihar Gold Mines Limited. It was held that when a government servant or one in a public undertaking is suspended pending a departmental inquiry against him, subsistence allowance must be paid to him. The court has emphasized that a government servant does not have his right to life and other fundamental rights. However, if a person is deprived of a right according to procedure established by law, which must be fair, just, and reasonable, and in the larger interest of the people, the plea of deprivation of right to livelihood under Article 21 is unsustainable.
ये यहाँ पर कह
Chameli
रहा है,
Singh,
सबसे से लाभ की बात कर रहा है, बाकी डिपार्टमेंटल इंक्वायरी में अलग से इसका भी है, लैंडमार्क जजमेंट है.
बिल्कुल बिल्कुल. और फिर वो आपका रूल्स है ना गवर्नमेंट का, स्टेट का रूल्स है, सेंट्रल रूल्स है, सब सारे रूल्स उसमें बने हुए हैं. हाउ द इंक्वायरी शुड बी कंडक्टेड, अंडर व्हाट प्रोविजन नोटिस टू शो कॉज कैन बी इशूड, देन द टाइम शुड बी गिवन फॉर हिम टू रिप्लाई, प्रॉपर टाइम शुड बी गिवन, देन इंक्वायरी ऑफिसर शुड बी अपॉइंटेड, डिसिप्लिनरी अथॉरिटी का क्या रूल है, क्या उनका रोल है, दैट इज एक्सप्लेन्ड.
चमेली सिंह इम्पोर्टेंट
तो
है इसमें, जो लैंड
हाँ सर.
एक्विजिशन एक्ट का उसका वो कर रहे थे लोग, देखो.
तो एक बाद में सर एक दिन हम लोग सर्विस लॉ का भी थोड़ा सा ये करेंगे.
हाँ हाँ हाँ.
In Chameli Singh versus State of UP, the Supreme Court held that the state acquired a landowner's land following the procedure laid down in relevant law of acquisition, matlab vesting. So even though the right to livelihood of the landowner is adversely affected, it is not violatory. So the court had acquired the land in exercise of powers for a public purpose, definitely, and compensation must have been paid.
ना.
Gigi, compensation must have been paid. So therefore, that person, after taking compensation, cannot say that, by my right to livelihood is gone.
ये लिख रहा है
So,
ना,
हाँ
ये
हाँ
पेड
हाँ.
कंपनसेशन इन प्लेस ऑफ लैंड लिख रहा है ना.
अच्छा 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 अच्छा. In MJ Shivani versus State of Karnataka and others, the Supreme Court held that the right to life under Article 21 does protect livelihood. However, the court added a rider, that is, deprivation could not be extended too far or projected or stretched to the recreation, business, or trade detrimental to the public interest. or has an insidious effect on public moral or public order, मतलब कोई illegal काम
प्रोस्टिट्यूशन
चलाना,
करने लग जाओ, जुआ खेलने लग जाओ, ये थोड़ा चलेगा।
जुआ खेलना, कोई बार चलाना जिसमें कोई गलत काम हो, तो
ये लिख
दैट
रहा है,
कैनॉट,
ये देखो ये लिख रहा
उस,
है यहाँ पे।
हाँ हाँ हाँ, games of pure chance or mixed chance and skill are not अच्छा, further held the regulating video games, हाँ, regulating, so regulations must always be there in these cases. Therefore, it cannot be said that these regulations are unjust. An important case that needs to be mentioned when speaking about the right to livelihood is MX of Bombay in Indian inhabitants versus Messrs. ZY. In this case, the court held that a person could not be denied employment if they tested positive for HIV, and they cannot be rendered medically unfit owing to the same. In interpreting the right to livelihood, the court emphasized that the same couldn't hang on the fancies of the individuals in authority.
Viewers, please be informed that here deliberately they are writing MX because these petitioners were HIV affected and they never want, the court never wanted to disclose the name. So you can file petition by such name.
Right, sir. Then the right to work is a fundamental right under Article 21. In Swadan Singh versus Delhi Municipal Committee, the five-judge bench of the Supreme Court distinguished the concept of life and liberty within Article 21 from the right to carry on any trade or business, a fundamental right conferred by Article 19(1)(g). Regarding the same, the court held that the right to carry on a trade or business is not included in the concept of life and personal liberty. Thus, Article 21 is not attracted in the case of trade or and business.
सही बात है, ट्रेड और बिजनेस नुकसान हो गया तो तुम बोलोगे मेरा राइट टू लाइफ जा रहा है,
चला
तो
गया
मुझे
लिब
compensate करो।
इसमें ये पर्टिकुलर केस में they were hawkers, the petitioners were hawkers, and the municipal authorities did not allow them to carry out their business. The court appointed that the petitioners had a fundamental right under Article 19(1)(g) to carry on trade or business of their choice. However, they had no right to do so in a particular place. मतलब सड़क रोक कर कोई business कर रहा हो on every road in the city. If the road is not wide enough to conveniently accommodate the traffic on it, no hawking may be permitted at all or permitted once a week. The court also held that footpaths, streets, and roads are public property intended to serve the general public and are not meant for private use. However, the court said that the affected persons could apply for relocation, and the concerned authorities were to consider the representation and pass orders thereon. Therefore, the two rights were too remote to be connected. फिर Olga Tellis में in this particular case, the petitioners were very poor persons who had made the payment their homes, and they had to stay on the payment so that they could get odd jobs in the city. It was not the case of business or selling articles after investing some capital. So it is distinguishing the former case, इसमें डिस्टिंक्शन ड्रॉ कर रहा है कि these people are just living, merely surviving on the footpath, but they were not engaged in any trading or activity
बिजनेस एक्टिविटी
by
था।
investing capital. Huh? In Secretary, the state of Karnataka versus Uma Devi, the court rejected that the right to employment at the present point of time can be included as a fundamental right under right to life under Article 21. सबको तो एम्प्लॉयमेंट नहीं दे सकते हैं ना, देन
तुम जो
दैट पर्सन
मिनिमम
मस्ट बी सूटेबल,
जो मिनिमम क्राइटेरिया है उसको क्वालिफाई करो, ले लो
हाँ उसको
एम्प्लॉयमेंट
फुलफिल
चाहिए
करना
तो।
पड़ेगा.
राइट, तो तुम कोई भी आ जाएगा लेने के लिए।
राइट टू शेल्टर in UP Awas Vikas Parishad versus Friend Cooperative Housing Society Limited, the right to shelter has been held as a fundamental right which springs from the right to residence secured under Article 19(1)(e) and the right to life guaranteed under Article 21. The state has to provide facilities and opportunities to build houses to make the right meaningful for the poor. Upholding the importance of the right to a decent environment and a reasonable accommodation in Shanti Star Builders versus Naran Khimalal Totame, the court held the right to life would take within its sweep the right to food, the right to clothing, the right to decent environment and reasonable accommodation to live in. The difference between the need of an animal and a human being for shelter has to be kept in view. The court advanced. For the animal, it is the bare protection of the body. For a human being, it has to be a suitable accommodation, which would allow him to grow in every aspect physical, mental, and intellectual. The Constitution aims at ensuring fuller development of every child. That would be possible only if the child is in a proper home. It is not necessary that every citizen must be ensured of living in a well built, comfortable house, but a reasonable home, particularly for people in India, can even be a mud built thatched house or a mud built fireproof accommodation. फिर चमेली सिंह वर्सेस स्टेट ऑफ यूपी इसमें थ्री जज बेंच ऑफ द सुप्रीम कोर्ट considered and held that the right to shelter is a fundamental right available to every citizen, and the same was read into Article 21 of the Constitution. Thus, right to shelter was considered encompassing the right to life, making the latter more meaningful. वही बोल रहा shelter should provide pure air, proper space to grow everything. Right to social security and protection of family. Right to life covers within its ambit the right to social security and protection of the family. Justice K. Ramaswamy in Calcutta Electric Supply Corporation India Limited versus Subhash Chandra Bose held that the right to social and economic justice is a fundamental right under Article 21. The learned judge explained right to life and dignity of a person and status without means were cosmetic rights.
No, no, no,
Socio-economic
no,
rights
no.
were
एक मिनट right to life and this without means
without means.
yes.
Right to life and dignity of a person and status without means. विदाउट मीन्स मतलब उसका उसके हाथ में कोई मतलब तरीका ही
साधन
नहीं
है
है
नहीं कुछ
कुछ।
बेचारा कैसे रहेगा वो
हाँ, तो फिर कॉस्मेटिक ही बन जाता है
हाँ.
if he has nothing at all. So socio-economic rights were therefore basic aspirations for meaning the right to life and thus right to social security and protection of family were an integral part of the right to life. In NHRC versus State of Arunachal Pradesh, the Supreme Court held that the state is bound to protect the life and liberty of every human being. He is a citizen, or if he is a citizen or otherwise. Further, it cannot permit anybody or a group of persons to threaten another person or group of persons. No state government worth the name can tolerate such threats. But this was, I think, some insurgent group which was threatening the government. No state government worth the name can tolerate such threats from one group of persons or to another group of persons. Therefore, the state is duty bound to protect the threatened group from such assaults. If he fails to do so, it will fail to perform its constitutional as well as statutory obligations.
कि मणिपुर में क्या हो रहा है
तो इसके अगेंस्ट में ही जा रहा है टू ग्रुप्स आर फाइटिंग
इसलिए तो जाकर 5 दिन बैठे रहे हमारे होम मिनिस्टर साहब वहां पे
लेकिन अभी कुछ ठंडा हुआ सर
हाँ हाँ ठंडा हुआ उन लोगों ने सरेंडर किया ना एंड आई थिंक अमित शाह हैज प्रॉमिस दैट हेलीकॉप्टर सर्विस बीइंग प्रोवाइडेड टू क्या है कैरी ऑन द
evacuate people in cases
नहीं
of emergency.
इसेंशियल कम्युनिटीज आल्सो देर हो जाती है ना ऊपर पहाड़ में
अच्छा
जाने
अच्छा
में
हाँ हाँ हाँ
उसके लिए
हाँ
वो बोलते हैं कि ये लोग नीचे वाले जो मैती है ना ये लोग सबके सब अपने पास में रख लेते हैं हमारे पास पहुंच नहीं पाते हैं उसके लिए भी कुछ अरेंजमेंट किया है लोगों ने
लेकिन ये मैती वाले तो अलग चीज बोल रहे हैं
क्या बोलेंगे अब वो जाने दो वो तो जहां पर भी झगड़ा होता है कुछ ना कुछ गड़बड़ करते हैं सरकार क्या कर रही है अपने को उसके बारे में देखने का है
इन मुरलीधर दयानदेव केसेकर versus Vishwanath Pandey Barde, it was held that the right to economic empowerment of the poor, disadvantaged, and oppressed Dalits was a fundamental right to make the right of life and dignity of person meaningful. For in Regional Director ESI Corporation versus Francis de Costa, the Supreme Court held that security against sickness and disablement was a fundamental right under Article 21, read with Section 39E of the Constitution of India. In LIC of India versus Consumer Education and Research Center, it was further held that right to life and livelihood included right to life insurance policies of LIC of India, but that it must be within the paying capacity and means of the insured.
हम्म हम्म
पॉलिसी खोलकर फिर आगे चला नहीं पाया तो फिर फायदा कुछ नहीं. Further, Surjit Kumar versus State of UP is a crucial case that reads Article 21 as extending protection against honor killing. In the case, a division bench of Allahabad High Court took a serious note on harassment, ill-treating, and killing of a person who wanting to get married to a person of another caste or community. The accused justified the harassment and killing, claiming that the victim had brought dishonor to the family. The court said that such a practice of honor killing was a blot on society, and intercaste marriage was not against the law. Therefore, the court directed the police to take strong measures against the accused. Right to health and medical care in state of
ठीक
Punjab
है ना,
versus
इसको ऐसे
MS
पढ़
Chawla.
दो, ये पढ़ दो बस, स्टेट ऑफ पंजाब में ऐसा
हाँ,
करके है,
हाँ.
विंसेंट में ऐसा है, ऐसे छोड़
Right
दो.
to life guaranteed under Article 21 includes the right to health and medical care. फिर विंसेंट वर्सेस यूनियन ऑफ इंडिया में बोल रहा है फर्दर
हेल्दी
आर्टिकल
बॉडी द वेरी
47.
फाउंडेशन ऑफ ह्यूमन एक्टिविटीज.
Directive principle of state policy lays stress note on the improvement of public health and prohibition of drugs detrimental to health as one of the primary duties of the state. ये important है सर. Improvement of public health and prohibition of drugs detrimental to health as one of the primary duties of the state. सर एक जमाने में डीडीटी यूज होता था तो उसका
यस,
आफ्टर इफेक्ट्स बहुत बुरा था. देखिए अभी वो खत्म हो गया एकदम.
हाँ, वो मच्छर मारने के लिए आते थे डीडी छिड़कने के
हाँ,
लिए.
हाँ, हाँ. हम लोग भी बचपन में देखे हैं सर.
हाँ.
In Consumer Education and Research Center versus Union of India, the Supreme Court laid down social justice, which is a device to ensure life to be meaningful and livable with human dignity, requires the state to provide to workmen facilities and opportunities to reach at least minimum standards of health, economic security, and civilized living. The health and strength of the worker, the court said, was an important facet of right to life. Denial thereof denudes the workman the finer facets of life, violating Article 21. उनको वर्कर्स को
ये
प्रॉपर
भी इम्पोर्टेंट जजमेंट है,
अपॉर्चुनिटी.
परमानंद कटारा.
परमानंद कटारा वर्सेस यूनियन ऑफ इंडिया.
ये वो है ना जो एक्सीडेंट में किनारे में पड़ा हुआ था बेचारा रोड में,
हाँ,
वही है
हाँ,
ना
हाँ.
जो.
Preservation of life is of paramount importance. The apex court stated that once life is lost, status quo ante cannot be restored. अब मरने के बाद तो जिंदा तो नहीं होगा. It was held that it is the professional obligation of all doctors, government or private, to extend medical aid to the injured immediately to preserve life without legal formalities to be complied with by the police.
इस केस के
Artic-
बाद में अब डॉक्टर लोग इंसिस्ट नहीं करते, नहीं तुम एफआईआर करवा के लेकर के आओ, ये
हाँ,
करवा के
पहले
लेकर
करवा के
आओ.
ले आइए, पुलिस में कंप्लेन करा के ले आइए, तब ट्रीटमेंट करूंगा. Article 21 casts the obligation on the state to preserve life. It is the obligation of those in charge of the community's health to protect life so that the innocent may be protected and the guilty may be punished. No law can intervene to delay and discharge this paramount obligation of the members of the medical profession.
मैंने मैंने ये लिया था, लॉ ऑफ मेडिसिन लिया था मैंने,
जी, जी, जी.
इसलिए उसमें पढ़ाया जाता, परमानंद कटारा पढ़ाया जाता है उसमें.
इसको पढ़ूं सर. द कोर्ट
नहीं,
ऑब्जर्व आर्टिकल 21 ऑफ द
नहीं, 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 नहीं,
कॉन्स्टिट्यूशन.
नहीं.
सेम चीज है वो. सेम चीज को ही
तो
बताया.
ये पढ़ लो, दिस लिंक.
This link between the right to medical care and health, article and Article 21 played out most vividly during the pandemic, especially since the state couldn't manage the crisis and many people were left to fend for themselves.
ये कोविड-19 की बात कर रहा है.
हाँ, हाँ, हाँ. पैंडेमिक वही है अपना. Coming back to understanding the right to medical care pre-COVID era, another case that understands this link better is Paschim Banga Khet Mazdoor Samiti versus State of West Bengal. In this case, a person suffering from severe head injuries from a train accident was refused treatment at various hospitals on the excuse that they lacked the adequate facilities and infrastructure to provide treatment. Through this case, the Supreme Court developed the right to emergency treatment. The courts went on to say that the failure on the part of the government hospital to provide timely medical treatment to a person in need of such treatment results in the violation of his right to life guaranteed under Article 21.
तो यू कैन नॉट से दैट मेरे हॉस्पिटल में फैसिलिटी नहीं है। भाई फैसिलिटी बनाओ, अगर
अच्छा,
हॉस्पिटल है
नहीं
तो
भी
वहां फैसिलिटी बनानी
प्राइमरी,
चाहिए।
नहीं प्राइमरी ट्रीटमेंट तो देना ही होगा।
यही ना।
अब लोग डरते हैं कि वो मर जाए, कुछ हो जाए, तो फिर लोग मतलब पत्थर मारेंगे या तोड़ फोड़ करेंगे। It is it acknowledged the limitation of financial resources to give effect to such a right. Still, it maintained that the state needed to provide for the resources to give effect to the people's entitlement of receiving emergency medical treatment. The emergency medical treatment तो हर हॉस्पिटल में होना ही चाहिए. It has been reiterated time and again that there should be no impediment to providing emergency medical treatment. Again in प्रभात कुमार मुखर्जी, ये कलकत्ते में ज़्यादा होता है सब गड़बड़. Versus Ruby General Hospital and others, it was held that a hospital is duty bound to accept accident victims. This is a private hospital, and patients who are in critical condition, and that it cannot refuse treatment on the ground that the victim is not in a position to pay the fee or meet the expenses, or on the ground that there is no close relation of the victim available who can give consent for medical treatment. ये बहुत important है सर.
यस, वेरी इंपॉर्टेंट।
अब कोई बाहर का आदमी मान लीजिए ले आता है, तो वी कैन नॉट से कि पैसे नहीं है अभी, आई कैन नॉट एडमिट यू. द कोर्ट हेल्ड हैज laid stress on a crucial point, namely the state cannot plead lack of financial resources to carry out these directions meant to provide adequate medical treatment to the people. The state cannot avoid its constitutional obligation to provide adequate medical assistance to people on account of financial constraints. But in the
कब का
case,
जजमेंट है ये? 96?
हाँ जी,
मतलब 96 मैंने कम्युनिस्ट थे वहां पे।
हाँ,
एल
नहीं
का
अभी भी
एल
भगा देते हैं, ऐसा
नहीं,
बात नहीं है,
2005
अभी भी.
2005 का है। अभी भी कम्युनिस्ट है ना। 2011 में आए ना मैडम तो।
हाँ 11 में आई तो ये. इन कॉन्फेडरेशन, अच्छा ये भी पढ़ो, स्टेट ऑफ पंजाब वर्सेस राम लुभाया बग्गा. द सुप्रीम कोर्ट recognized that provision of health facilities could not be unlimited. The court held that it has to be to the extent finance permits. No country has unlimited resources to spend on any of its project. मतलब रीजनेबल एक्सपेक्टेशन के बाहर हो तो दैट इज नॉट एप्लीकेबल ना.
हाँ, बेयर मिनिमम फैसिलिटी तो होनी चाहिए ना।
हाँ
ये तो
होनी
किसी
चाहिए एटलीस्ट फॉर इमरजेंसी ट्रीटमेंट.
वो जैसे हुआ ना, एक लड़का जो है वो वहां पर मर्चरी में पड़ा हुआ था।
जी जी
उसके शायद पेरेंट्स गए वहां पर, उसको उठाया वहां से, बाद में फिर बालासोर में उसका ट्रीटमेंट करवाया, बाद में फिर कलकत्ता लेकर के आए ना उसको।
जी
उसके
जी.
हाथ हिल रहे थे, कुछ ऐसा करके था, बट दे थॉट दैट ही इज डेड, तो उसको किनारे में डाल
ही
दिया।
इज डेड. हाँ ही इज डेड. दे थॉट दैट ही इज डेड. No right to die. While Article 21
मैंने
confers
ऊपर
on a
वाला
person the
कंपटीशन वाला
right to,
प्रोडक्ट सर्विस में
अच्छा,
वाला।
in Confederation of Ex-Servicemen Association versus Union of India, the right to get free and timely legal aid and facilities was not held as a fundamental right of ex-servicemen. लेकिन अभी तो राइट टू लीगल एड तो है फॉर पीपल हु कैन प्रूव दैट दे डोंट हैव द मींस टू डू सो. लीगल एड आपका सर्विसेज तो हर कोर्ट में अवेलेबल है.
इसके बाद ही
Therefore,
किया
a
होगा ना।
policy decision, in formulating a contributory scheme for ex-servicemen and asking them to pay a one-time contribution does not violate Article 21, nor is it inconsistent with Part 4 of the Constitution. No right to die. While Article 21 confers on a person the right to live a dignified life, it does not confer on a person the right to end his life. So,
बस
if
इट
so,
ऑल्सो कन्फर करके बोल रहा है वो, इट डज नॉट नहीं है,
मैं
डज
मैं
इट ऑल्सो।
if so, then what is the fate of Section 309 IPC, which punishes a person convicted of attempting to commit suicide? There has been a difference of opinion on the justification of this provision to continue on the statute book. The question came up for consideration for the first time before the High Court of Bombay in state of Maharashtra versus Maruti Sripati Dubal. In this case, the Bombay High Court held that the right to life guaranteed under Article 21 includes the right to die. The Honorable Court struck down Section 309 of the IPC that provides punishment for an attempt to commit suicide on a person as unconstitutional. In P. Rathinam versus Union of India, a two-judge division bench of the Supreme Court took cognizance of the relationship contradiction between Section 309 IPC and Article 21. The court supported the decision of the High Court of Bombay in the above case, the Marutiwala case, and held that the right to life embodied in Article 21 also embodied in it the right not to live a forced life to his detriment, disadvantage, or disliking. The court argued that the word life in Article 21 means the right to live with human dignity, and the same does not merely connote continued drudgery. Thus, the court concluded that the right to live, of which Article 21 speaks, could bring in the right not to live a forced life. The court further emphasized that an attempt to commit suicide is in reality a cry for help and not for punishment. For help, होगा ये, for help, a cry for help and not for punishment. In the Rathinam ruling came to be reviewed by a full bench of the Supreme Court in Gyan Kaur versus State of Punjab. The question
ये
before the
कब का है
court was
ज्ञान कौर कब का है?
number कितना बता रहा है सर?
ये
1996.
हाँ 1996 का हाँ
The question before the court was: is the principal offense of attempting to commit suicide is void as constitutional vis-a-vis Article 21? Then how abetment can thereof be punishable under Section 306 IPC?
वो भी गड़बड़ था
It
ना.
was, हाँ हाँ हाँ. It was argued that the right to die has been included in Article 21 by the Rathinam ruling and Section 309 declared unconstitutional. Thus, any person abetting the commission of suicide by another is merely assisting in enforcing his fundamental right under Article 21. The court overruled the decision of the division bench
कुएं
of
में
the
डाल दो
above
उसके,
stated
बोलो सुसाइड कर रहा था, मैंने धक्का दे दिया उसको.
and has put an end to the controversy and ruled that Article 21 is a provision guaranteeing the protection of life and personal liberty, and by no stretch of imagination can extinction of life be read to be included in the protection of life. The court further observed right to life is a natural right embodied in Article 21, but suicide is an unnatural termination or extinction of life and therefore incompatible and inconsistent with the concept of right to life. However, in this regard, in 2022, the Supreme Court had sought a response from the central government. The court asked the center to explain its stance on the conflict between
देखा
Section
हट गई ना.
309 and the Mental Health Care Act promulgated in 2017, as opposed to Section 309, which criminalizes and or attempts to suicide. The MHCA prescribes prosecution of the person attempting it, given that the section is colonial legislation, may have vocalized to do away with the same altogether. Additionally, in 2018, in a 134-page long judgment, Justice D.Y. Chandrachud said it was inhuman to punish someone who was already distressed.
हम्म. अभी तक
सुसाइड
बर्बाद कर
करने
रहा है.
वाला जो है is already distressed. Euthanasia and right to life. Euthanasia is the termination of the right to life of a person who is terminally ill or in a permanent vegetative state. In Gyan Kaur versus State of Punjab, the Supreme Court has distinguished between euthanasia and an attempt to commit suicide. The court held that death due to termination of natural life is certain and imminent, and the process of natural death has commenced. Therefore, these are not cases of extinguishing life, but only of accelerating the conclusion of the process of natural death that has already started. The court further held that this might fall within the ambit of the right to live with human dignity up to the end of natural life. This may include the right of a dying man to also die with dignity when his life is ebbing out. However, this cannot be equated with the right to die an unnatural death, curtailing the natural span of life. Sentence of death, rarest of rare cases. The Law Commission of India has dealt with the issue of abolition and retention of capital punishment, collecting as much available material as possible and assessing the views expressed by Western scholars. The Commission recommended the retention of capital punishment in the present state of the country. The Commission held recognized the on ground conditions of India. By that, it meant the difference in the social upbringing, morality, and education, its diversity and population. Given all these factors, India could not risk the experiment of abolition of capital punishment. In Jagmohan vs. State of UP, the Supreme Court has held that the death penalty was not violative of Articles 14, 19, and 21. It was said that the judge was to make the choice between the death penalty and imprisonment for life based on circumstances, facts, and nature of crime brought on record during trial. Therefore, the choice of awarding death sentence was done in accordance with the procedure established by law as required under Article 21. But in Rajendra Prasad versus State of UP, Justice Krishna, speaking for the majority, held that capital punishment would not be justified unless it was shown that the criminal was dangerous to society. The learned judge pleaded for the abolition of the death penalty and said that it should be retained only for white collar crimes. ये कौन सा तर्क हुआ सर?
सही
मतलब
कह रहे हैं ना।
मर्डर,
व्हाइट
हाँ
कॉलर क्राइम मीन्स इकोनॉमिक ऑफेंसेस
हाँ,
की बात कर
पैसा
रहे हैं।
मान लीजिए कोई पैसा काफी चुराया, कुछ किया
इट इट अफेक्ट्स द पब्लिक एट लार्ज ना।
हाँ हाँ,
ही डिप्राइव्स many person राइट ऑफ
और
लाइफ ना।
देर
राइट ऑफ लाइफ और उसके में एजुकेशन भी आ जाता है, क्योंकि अगर आपका फंड चोरी कर लिया आपने तो पक्की बात है
हाँ,
उसके
तो
तो पहले सारे राइट गए ना।
कोई 300-500 करोड़ लेके भाग गया।
हाँ, जैसे अपने हमारे भाई साहब लोग हैं, वो किंगफिशर वाला है, ललित मोदी है, नीरव
सब
मोदी
सब
है, ये
ये
लोग।
सब।
बट माना कहाँ उसको, वो तो उनका व्यू पर वो किया था बस।
However, in Bachchan Singh versus State of Punjab, the leading case on the question, a constitution bench of the Supreme Court explained that Article 21 recognized the right of the state to deprive a person of his life in accordance with just, fair, and reasonable procedure established by valid law. It was further held that the death penalty for the offense of murder awarded under Section 302 of the IPC did not violate the basic feature of the Constitution, right to get pollution free water and air. Subhas Kumar versus State of Bihar. ये PIL था, it was maintainable for enjoying pollution free water and air, which included the right to live under Article 21. Then clean environment. Right to life means right to live a life of dignity in a proper environment free from dangers of diseases and infection. Maintenance of health, preservation of sanitation and environment have held to fall within the purview of Article 21 as it adversely affects the life of citizens and it amounts to slow poisoning, reducing the life of the citizens because of the hazards created if not checked. अब सर ये फैक्ट्री से इतने पोल्यूटिंग गैसेस, सल्फर डाइऑक्साइड फलाना ये वो सब निकल रहा है, इतना कार्बन फुटप्रिंट है अपना ये व्हीकल्स के चलते, दैट इज आल्सो किलिंग पर्संस ग्रेजुअली।
वो सस्टेनेबल डेवलपमेंट की बात करता है ना फिर।
बात करता है सर, देन दे शुड गो फॉर इलेक्ट्रिफिकेशन और सम अदर मींस।
कर तो रहे हैं, आज के डेट में सब चल रहा है ना।
इन एमसी मेहता वर्सेस यूनियन ऑफ इंडिया जितना जल्दी करें सर। 1988 द सुप्रीम कोर्ट ऑर्डर्ड द क्लोजर ऑफ टैनरीज polluting the water. Then in the same case, no, this is a different case of
ताजमहल वाला है,
1997.
ताजमहल वाला है।
Further, the Supreme Court issued several guidelines and directions for the protection of the Taj Mahal, an ancient monument, from environmental degradation. In Fellow Citizens Welfare Forum versus Union of India, the court
इको
took
टेररिस्ट की
cognizance
बात
of
कर
the
रहा है।
environmental problems being caused by tanneries that were polluting the water resources, rivers, canals, etc. The court directed that the problem be dealt with. Milkman Colony Vikas Samiti versus State of Rajasthan. The Supreme Court held that the right to life means clean surroundings which lead to a healthy body and mind. It includes the right to freedom from stray cattle and animals in the urban areas. फिर MC Mehta versus Union of India 2006. The court held that the blatant and large-scale misuse of residential premises for commercial use in Delhi violated the right to a salubrious and decent environment. Taking note of the problem, the court issued directives to the government on the same. Murli as Devra versus Union of India. The person not indulging in smoking cannot be compelled to be subjected to passive smoking on account of the act of smoking. Therefore, the right to life under Article 21 is affected, as a non-smoker may become a victim of someone smoking in a public place. ये फिर भी अभी चेक में है सर. This problem has, I mean, not aggravated so much अभी, क्योंकि स्मोकिंग जोन्स बना दिया गया है बहुत जगह पे. And non-smoking is there in railway platforms, in all airports, in all offices. Right against
बहुत
noise pollution.
बहुत सही किया हो.
In this case, noise pollution caused by obnoxious noise levels due to the bursting of crackers during Diwali. The apex court suggested to desist from bursting and making use of such noise-making crackers, and observed that Article 21 of the Constitution guarantees the life and personal liberty to all persons. It guarantees the right of persons to life with to live with ये live होगा to live to life with human dignity. There, therein are included all the aspects of life which go to make a person's life meaningful, complete, and worth living. The human life has its charm, and there is no reason why life should not be enjoyed along with all permissible pleasures. Anyone who wishes to live in peace, comfort, and quiet within his house has a right to prevent the noise as pollutants reaching him. इसके बाद no one can claim the right to create noise even in his own premises that would travel beyond his precincts and cause nuisance to neighbors or others. Any noise which has the effect of materially interfering with the ordinary comforts of life, judged by the standard of a reasonable man, is nuisance. While one has the right to speech, others have the right to listen or decline to listen. Nobody can be compelled to listen, and nobody can claim that he has a right to make his voice trespass into the ears or minds of others. Nobody can indulge in oral aggression. Oral matlab to do with the ear. If anyone increases his volume of speech, and that too with the assistance of artificial devices, so as to compulsorily expose unwilling persons to hear a noise raised to unpleasant or obnoxious levels, then the person speaking is violating the right of others to a peaceful, comfortable, and pollution free life guaranteed by Article 21. Article 91A cannot be pressed into service for defeating the fundamental right guaranteed by Article 21. Right to know. Holding that the right to life has reached new dimensions and urgency, the Supreme Court in RP Limited versus Proprietors India Express newspapers Bombay Private Limited observed that if democracy has to function effectively, people must have the right to know and to obtain knowledge of the conduct of the affairs of the state. In SR Oil Limited versus Halar Utkarsh Samiti, the Supreme Court held there was a strong link between Article 21 and the right to know, particularly where secret government decisions may affect health, life, and livelihood. Reiterating the above observations made in the instant case, the apex court in Reliance Petrochemicals Limited versus Proprietors of Indian Express newspapers ruled that the citizens who had been made responsible for protecting the environment had the right to know the government proposal with personal liberty. The liberty of the person is one of the oldest concepts
ये
to be
हीरो
protected.
रिलायंस वाला
जी
गया
सर.
था एक्सप्रेस के खिलाफ.
हाँ हाँ.
तो एक्सप्रेस ने कुछ लिख दिया, तो उसी में सुप्रीम कोर्ट ने बोला है कि भाई ऐसा है, बकवास मत करो, दे हैव गॉट राइट टू नो.
The liberty of the person is one of the oldest concepts to be protected by national courts. As long as 2015, the English Magna Carta provided, no free man shall be taken or imprisoned but by the law of the land. The smallest article of 18 words has greatest significance for those who cherish the ideals of liberty. What can be more important than liberty? In India, the concept of liberty has received a far more expansive interpretation. The Supreme Court of India has rejected the view that liberty denotes merely freedom from bodily restraint, and has held that it encompasses those rights and privileges that have long been recognized as being essential to the orderly pursuit of happiness by free men. The meaning of the term personal liberty was considered by the Supreme Court in Khadak Singh's case, which arose out of the challenge to the constitutional validity of the UP police regulations that provided for surveillance by way of domiciliary visits and secret picketing. Oddly enough, both the majority and the minority on the bench relied on the meaning given to the term personal liberty by an American judgment in Munn versus Illinois, which held the term life meant something more than mere animal existence. The prohibition against its deprivation extended to all those limits and faculties by which life was enjoyed. The provision equally prohibited the mutilation of the body or the amputation of an arm and leg or the putting of an eye or the destruction of any other organ of the body through which the
ये
soul communicated with the outer
पुलिंग
world.
चाहिए, ये पुलिंग होना चाहिए ना,
Hmm.
पुलिंग होना चाहिए.
Pulling out of an eye. Misprint होगा सर. The majority held that the UP police regulations authorizing domiciliary visits at night by police officers as a form of surveillance constituted a deprivation of liberty and thus unconstitutional. The court observed that the right to personal liberty in the Indian Constitution is the right of an individual to be free from restrictions or encroachment on his person, whether they are directly imposed or indirectly brought about by calculated measures.
हम्म.
The Supreme Court has held that even lawful imprisonment does not spell farewell to all fundamental rights. A prisoner retains all the rights enjoyed by a free citizen except those necessarily lost as an incident of imprisonment. मतलब खाना वगैरह प्रॉपर रहने का जगह ये सब देना
सिक्योरिटी भी
चाहिए.
ना, अभी जैसे उसको मार
बिल्कुल,
दिया,
बिल्कुल.
अतीक को मार दिया, उसके भाई को मार दिया, आज दिल्ली कोर्ट में मार दिया किसी को, दैट शुड नॉट बी अलाउड ना. उसका
जी, जी,
राइट तो
जी.
है ना उसके, यू हैव टू प्रोटेक्ट हिज लाइफ.
Right to privacy in Article 21, although not explicitly mentioned in the Constitution, the right to privacy was considered a penumbral right under the Constitution, that is, a right declared by the Supreme Court as integral to the fundamental right to life and liberty. After the K.S. Puttuswamy judgment, the right to privacy has been read and understood by the court in various landmark judgments. The
पुट्टे स्वामी
Supreme Court,
जजमेंट कौन सा है? आधार कार्ड वाला,
हाँ हाँ, the
चंद्रचूड़
Supreme
साहब
Court
लिखा
has,
है.
हाँ वही. The Supreme Court has culled the right to privacy from Article 21, another provision of the Constitution read with the directive principles of state policy. Although no single statute confers a cross cutting horizontal right to privacy, various statutes had provisions that either implicitly or explicitly preserved this right. For the first time in Khadak Singh versus State of UP, the court questioned whether the right to privacy could be implied from the existing fundamental rights, such as Article 19(1)(d), 19(1)(e), and 21, which came before the court. Surveillance under Chapter 2020 of the UP police regulations constituted an infringement of any of the fundamental rights guaranteed by Part 3 of the Constitution. Regulation 236B, which permitted surveillance by domiciliary visits at night, domiciliary अच्छा visits at night, मतलब घर घर पे जो रात को जो ये लोग आते थे पुलिस ऑफिसर्स,
हाँ हाँ हाँ, उसको ही
was
मना
held
किया.
to violate Article 21. A seven-judge bench held the meaning of the expression life and personal liberty in Article 21 were considered by this court in Khadak Singh's case, although the majority found that the Constitution contained no explicit guarantee of a right to privacy. It read the right to personal liberty expansively to include a right to dignity. It held that an unauthorized intrusion into a person's home and the disturbance caused to him thereby is, as it were, the violation of a common law right of a man, an ultimate essential of ordered liberty, if not of the very concept of civilization. In the minority judgment in the case, Justice Subba Rao held, the right to personal liberty takes in not only a right to be free from restrictions placed on his movements, but also free from encroachments on his private life. It is true, our Constitution does not expressly declare a right to privacy as a fundamental right, but the said right is an essential ingredient of personal liberty. Every democratic country sanctifies domestic life. It is expected to give him rest, physical happiness, peace of mind, and security. In the last resort, a person's house where he lives with his family is his castle. ये इंग्लिश लॉ में भी है.
Hmm.
A man's home is his castle. It is his it is his rampart, like the ramparts of a fort. It is his rampart against encroachment on his personal liberty. This case, especially Justice Subbarao's observations, paved the way for later elaborations on the right to privacy using Article 21. Govind was the state of Madhya Pradesh. The Supreme Court took a mere elaborate appraisal of the right to privacy. In this case, the court was evaluating the constitutional validity of Regulation 855 and 856 of the MP Police Regulations, which provided for police surveillance of habitual offenders, including domiciliary visits and picketing of the suspects. The Supreme Court desisted from striking down these invasive provisions, holding that it cannot be said that surveillance by domiciliary visit would always be an unreasonable restriction upon the right to privacy. Right of privacy is only persons who are suspected to be habitual criminals and those who are determined to lead a criminal life that is subjected to surveillance. इसमें तो
क्या
उल्टा
करेगा वो?
बोल रहा है.
किसी को बोल देगा, फिर वो किसी को बोलेगा आप सस्पेक्टेड है वो.
The court accepted a limited fundamental right to privacy as an emanation from Article 19A(d) and 21. Justice Matthew observed in the instance case, the right to privacy will therefore necessarily have to go through a process of case by case development. Hence, assuming that the right to personal liberty, the right to move freely throughout India, and the freedom of speech create an independent fundamental right of privacy is an emanation from them that one can characterize as a fundamental right. We do not think that the right is absolute. Assuming that the fundamental rights explicitly guaranteed to a citizen have been penumbral zones and that the right to privacy is itself a fundamental right, that fundamental right must be subject to restrictions on the basis of compelling public interest. Yeah, this makes sense. Compelling public interest यदि हो, then it will be subject to restrictions.
हम्म.
Scope and content of right to privacy. Tapping of telephone is permissible in India under Section 52 of the Telegraph Act. The Supreme Court in PUCL versus Union of India held that in the absence of just and fair procedure for regulating the exercise of power under Section 52 of the Act, it is not possible to safeguard the fundamental rights of citizens under Section 19 and 21. 21. Accordingly, the court issued procedural safeguards to be observed before restoring to telephone tapping under Section 52 of the Act. The court further ruled that right to privacy is a part of right to life, personal liberty enshrined under Article 21.
मतलब ये
Right
किसी
to
भी ऐसे आदमी का
नहीं.
फोन टैप कर सकते हैं, उसके लिए भी कंसेंट चाहिए ना गवर्नमेंट का.
हाँ, गवर्नमेंट का कॉन्सेंट तो चाहिए सर. इसमें बोला गया would certainly include telephone conversation in the privacy of one's home and office, but telephone tapping would infract Article 21 unless it is permitted under the procedure established by law. The procedure has to be just, fair, and reasonable. Disclosure of dreadful diseases. In Mr. X versus Hospital Z, the question before the Supreme Court was whether the disclosure by the doctor that his patient who was to get married had tested HIV positive would be violative of the patient's right to privacy. The Supreme Court ruled that the right to privacy was not absolute and might be lawfully restricted for the prevention of crime, disorder, protection of health or morals, or protection of rights and freedom of others. The court explained that the right to life of a lady with whom the patient was to marry would positively include the right to be told that a person with whom she was proposed to be married was the victim of a deadly disease which was sexually communicable. Since the right to life included the right to a healthy life to enjoy all the facilities of the human body in prime condition, it was held that the doctors had not violated the right to privacy.
हम्म.
ये सही किया. Right to privacy and subjecting a person to medical tests. It is well settled that the right to privacy is not treated as absolute and is subject to such action as may lawfully be taken to prevent crimes or disorder, protect health or morals, or protection of rights and freedom of others. If there is a conflict between the fundamental rights of two parties which advances public morality, that which advances public morality
That
would
will
prevail.
prevail. That will prevail. हाँ.
Mhm. In the case of Sharda versus Dharmpal, a three-judge bench ruled that a matrimonial court had the power to direct the parties in a divorce proceedings to undergo a medical examination. A direction issued for this could not be held to violate one's privacy. The court, however, said that there must be sufficient material for this. कोई वजह होगा. राइट
शादी
टू
करने से
प्राइवेसी
पहले.
वुमेन्स ने कोई वजह तो होगा इसमें.
हाँ.
Right to privacy, women's right to make reproductive choices. A woman's right to make reproductive choices includes the woman's right to refuse participation in sexual activity or the insistence on using contraceptive methods such as undergoing sterilization procedures. The woman's entitlement to carry a pregnancy to its full term, to give birth subsequently and raise children. Whether the woman has a choice.
नहीं बच्चे
Right to
पैदा करना
travel
मेरे को.
abroad.
नहीं बच्चे पैदा करना मेरे को. है
हाँ,
ना. You cannot
वही तो
force.
बता रहा था. वही तो बता रहा है. और इसके चलते लोग कोर्ट भी जा रहे हैं. राइट टू
सतवंती
ट्रैवल
सानी और
अब्रॉड.
मेनका गांधी का क्या करना है? ये तो राइट टू ट्रेवल अब्रॉड की बात कर
ये
रहा है.
हाँ, ये तो हम लोग उसमें कवर किए हैं पिछले
हाँ,
एपिसोड में.
ये पढ़ो, ये पढ़ो, ये पढ़ो.
Illegal detention. In Jogendra Kumar versus State of UP, the petitioner was detained by the police officers and the whereabouts were not told to his family members for a period of 5 days, taking serious note of the police high-handedness. High-handedness होगा. An illegal detention of a free citizen. The Supreme Court laid down the guidelines governing arrest of a person during the investigation. An arrested person being held in custody is entitled, if he so requests, to have a friend, relative, or other person told as far as it is practicable that he has been arrested and where he is being detained. The police
इसलिए
officer
अरेस्ट
shall
करने के
inform
टाइम में
the
लिखवा लेते हैं दैट आई हैव इन्फॉर्म्ड माय वाइफ और व्हाटएवर इट इज रिलेटिव फ्रेंड दिस एंड दैट दैट आई हैव बीन अरेस्टेड. ऐसे करके लिखवा लेते हैं उसमें अर्स मेमो में.
GG. The police officer shall inform the arrested person when he is brought to the police station of this right. An entry shall be required to be made in the diary as to who was informed of the arrest. यही तो आप जो बोल रहे हैं. In the case of DK Vasu versus State of West Bengal,
ये
the
बहुत
Supreme Court laid
इंपॉर्टेंट है
down
भाई, बहुत इंपॉर्टेंट है.
detailed guidelines to be followed by the
यस, बहुत
central and
इंपॉर्टेंट
state
है. ये पब्लिक के लिए तो.
investigating agencies.
यस, ये तो बिल्कुल वो है, क्या बोलते हैं, रामबाण है. इसको रखो अपने पास में.
In the cases of arrest and detention. Furthermore, the court ordered that the guidelines be followed till legal provisions are made on that. अभी तो हो गया legal provision. It has been held that any form of torture or cruel, inhuman or degrading treatment, whether it occurs during interrogation or otherwise, follows within the ambit of Article 21. आजकल ये सर सीबीआई ईडी ऑफिस में चार्ट लगा दिया गया, तो बोर्ड बोर्ड पे लिखा हुआ रहता है ऑल दीज राइट्स.
यस यस यस.
कंपल्सरी कर दिया. Article 21 and prisoners' rights. The protection of Article 21 is available even to convicts in jail. The convicts are not deprived of all the fundamental rights they otherwise possess by mere reason of their conviction. Following the conviction of a convict put in jail, he may be deprived of his fundamental freedoms, like the right to move freely throughout the territory of India. But a convict is entitled to the precious right guaranteed under Article 21, and he shall not be deprived of his life and personal liberty except by a procedure established by law. फिर वो मानेगा गांधी पे आ रहा है. Right to free legal aid and right to appeal. जो जो मैं बोल रहा था, prisoner may be given the right to free legal aid, and even persons who are unable to, pay the legal fees. इसीलिए
कोर्ट देता है ना, फिर वो लीगल उसको देता है ना.
हाँ, कोर्ट देता है.
फीस कम मिलती है लेकिन देता तो है वो पूरा.
नहीं, बहुत लोग वैसे भी करते हैं, मतलब एक आध केस ले ही लेते हैं लोग. राइट
उसे
टू
नाम
स्पीडी
होता है ना
ट्रायल.
उनका, उसके लिए भी करते
हाँ
हैं ना
हाँ
वो.
हाँ हाँ हाँ. In
कोर्ट तो
Hushainara
वैसे भी
Khatun versus Home
कोर्ट
Secretary,
कोर्ट तो
State of
वैसे भी
Bihar.
जो थोड़ा-सा जब अगर सामने वाली बेंच में बैठा होता है ना, तो उसको बोलता है, "चलो ठीक है,
हाँ
यू
आप
एक्ट
ले लो, हाँ
लाइक यू
बोलता
टेक
यू
दिस केस
फ्रेंड ऑफ
या
द
अमिकस
कोर्ट
क्यूरी
आप
बन
ले लो,
जाओ।"
एमिकस क्यूरी, यू आर अपॉइंटेड एमिकस क्यूरी।
चलो बात करो।
बोलता है करेक्ट सर। तीन चार लोग ऐसे रहते हैं, कोर्ट उनके तरफ देखकर बोलता है कि आप ले लो इसको।
खानवलकर साहब कोर्ट में मैं घुसता नहीं था, वो पकड़ा देते थे केस बिना मतलब मेरे को, लो ये
हाँ हाँ,
छोड़ो। अब बोलते थे कम टू माय चैम्बर टू अंडरस्टैंड द केस आल्सो, ऐसे भी बोलते थे वो।
अच्छा अच्छा। In Hossanara Khatun versus Home Secretary, State of Bihar, the Supreme Court observed that an alarming number of men, women, and children were kept in prison for years awaiting trial in courts of law. The court noted the situation and observed that it was carrying a shame on the judicial system that permitted incarceration of men and women for such long periods without trials. The court held that detention of under trial prisoners in jail for a period of more than what they would have been sentenced to if convicted was illegal, and the same violated Article 21. The court ordered to release all under trial prisoners who had been in jail for a longer period than the punishment meted out in the case of conviction. In A.R. Antule versus R.S. Naik, a constitution bench of 5 judges of the Supreme Court
दिस
dealt
इज
with the question and laid down specific
इम्पोर्टेंट।
guidelines, important hai, for ensuring speedy trial of offences, some of which have been listed below. Fair, just, and reasonable procedure implicit in Article 21 creates a right in the accused to be tried speedily. Right to speedy trial, flowing from Article 21, encompasses all the stages, namely the stage of investigation, inquiry, appeal, revision, and retrial. The concerns underlying the right to speedy trial from the point of view of the accused are the period in remand and pre-conviction detention should be as short as possible. The worry, anxiety, expense, and disturbance to his vocation and peace resulting from an unduly prolonged investigation, inquiry, or trial should be minimal, and undue delay may well result in impairment of the ability of the accused to defend him. While determining whether the undue delay has occurred, one must regard all the attendant circumstances, including the nature of the offence, the number of the accused and witnesses, and the court's workload concerned. यहाँ तो बच जाएगा। वो court's workload concerned यहाँ बच जाएगा। My diary is full. Every delay does not necessarily prejudice the accused. An accuser's plea of denial of speedy trial cannot be defeated by saying that the accused did at no time demand a speedy trial. In the case of Anil Rai versus State of Bihar, the Supreme Court directed the judges of the High Courts to give quick judgments, and in certain circumstances, the parties are to apply to the Chief Justice to move the case to another bench or to do the needful at his discretion. Right to fair trial. तो लेकिन एक सर मैं बताऊं, जस्टिस हरेड इज ऑल्सो जस्टिस बरेड। ये भी
बकवास करते हैं लोग, ये ऐसे कुछ भी बोलते रहते हैं, चलता है। थोड़ा पढ़ो इसको, फेयर ट्रायल की बात कर रहे हैं।
right to fair trial. The free and fair trial has been said to be the sine qua non of Article 21. The Supreme Court in Zaira Habibullah Sheikh versus State of Gujarat said that the right to free and fair trial to the accused and the victims, the family members, and society at large. Right to bail. हाँ बेल इज द रूल, रिजेक्शन इज एन एक्सेप्शन। इसमें एंटिसिपेटरी बेल भी आ जाएगा। Incarceration of persons charged with non-bailable offences during the pendency of trial cannot be questioned as violative of Article 21, since the same is authorized by law. In Babu Singh versus State of Uttar Pradesh, the court held that the right to bail was included in the personal liberty under Article 21. Its refusal would be the deprivation of that liberty, which could be authorized in accordance with the procedure established by law. But bail is discretionary, sir. Yeah. Anticipatory bail is a statutory right, and it
मैंने
does
bail,
not.
right to bail means the person who is arrested can apply na,
Well, he can apply, but
and
it
then the
depends
court
on
has
the
to decide
discretion.
whether the investigation will be influenced after his release on bail. If he
And
feels
that is
like
precisely the deciding point.
वही ना, वहीं पर तो
That's
हो
why they
जाता है।
call for the case diary. हाँ, क्या है नहीं है. Right against handcuffing. Anticipatory bail is a statutory right and it does not arise out of Article 21. Therefore, anticipatory bail cannot be granted as a matter of right, as it cannot and it cannot be considered as an essential ingredient of Article 21. So it depends on the facts and circumstances which come prima facie. Handcuffing has been considered prima facie inhuman and therefore unreasonable, over harsh, and at first flush arbitrary. It has been held to be unwarranted and violative of Article 21. इसमें एक प्रेम शंकर केस में बोल रहा handcuffing should be resorted to only when there was clear and present danger of escape of the accused under trial, breaking out of police control. Right
Hmm.
against solitary confinement. It has been held that the convict is not wholly denuded of his fundamental rights, and his conviction does not reduce him into a non-person whose rights are subjected to the whims of the prison administration. Therefore, the imposition of any major punishment within the prison system is conditional upon the observance of procedural safeguard. In Sunil Batra versus Delhi administration, the petitioner was sentenced to death by the Delhi Session Court and his appeal against the decision was pending before the High Court. He was detained in Tihar jail during the pendency of the appeal. He complained that since the date of conviction by the Sessions Court, he was kept in solitary confinement. It was contended that Section 30 of the Prisoners Act does not authorize jail authorities to send him to solitary confinement, which by itself was a substantial punishment under sections 73 and 74 of the IPC and could be imposed by a court of law. Therefore, it could not be left to the whim and caprice of the prison authorities. The Supreme Court accepted the petitioner's argument and held that imposition of solitary confinement on the petitioner was violative of Article
It
21.
means that the court has to give strict matlab has to write in word that he should be confined solitarily. It's like that. Otherwise, क्योंकि हो सकता है कि वो डेंजरस हो, मार दे किसी को, सिर सुर फोड़ दे, ये भी तो सकता है.
लेकिन सर मैं बताऊं in all these cases where life imprisonment is given, they are always kept in solitary confinement. ये मैं देख कर आया हूँ सर inside the jail.
तो वो लोग अपने डायरी में कुछ लिखते होंगे बिकॉज ही इज डेंजरस और ही में कॉज कुछ करते होंगे लोग. बाकी तो लाइफ वाले तो बंदे जो है कोई खाना बना रहा होता है, कोई पैसा वसूल रहा होता है, कुछ भी करते हैं ना. मैं तो अर्थर रोड में देखा हूँ, लाइफ मिली है ना उनको, दे बिकम सरदार, नेता बन जाते हैं वो लोग.
कुछ लोगों को मतलब क्लरिकल काम भी दिया जाता है ना.
हम्म.
Those who are educated. The incidents of brutal police behavior towards persons detained on suspicion of having committed crimes are routine. There's been a lot of public outcry from time to time against custodial deaths. The Supreme Court has taken a very positive stand against the atrocities, intimidation, harassment, and use of third degree methods to extort confessions. The court has classified these as being against human dignity. The rights under Article 21 secure life with human dignity, and the same are available against torture. Death by
इसीलिए
hanging is
इसीलिए
not
कोर्ट
violent.
कभी कभी डायरेक्शन
हाँ
देता है ना दैट एडवोकेट हैज टू बी प्रेजेंट बट नॉट इन द
हाँ
हियरिंग
हाँ
डिस्टेंस,
बट
थोड़ा दूर रहेगा.
हाँ हियरिंग डिस्टेंस में ये सीबीआई ईडी केसेस में काफी मतलब बोला जाता है बिकॉज इन द अर्ली 80s and 90s they used to torture people a lot. धीरे धीरे एकदम वो खत्म हो गया. In Dina versus Union of India, the constitutional validity of the death sentence by hanging was challenged as being barbarous, inhuman, and degrading, and therefore violative of Article 21. The court in this case referred to the report of the UK Royal Commission, 1949, the opinion of the Director General of Health Services of India, the 35th report of the Law Commission, and the opinion of the prison advisors and forensic medicine experts. Finally, it held that death by hanging was the best and the least painful method of carrying out the death penalty, thus not violative of Article 21. The right against public hanging. The
अभी
Rajasthan High
किसी ने
Court by
डाला
an order.
सुप्रीम कोर्ट में, बोलता है पेनफुल है. सुप्रीम कोर्ट में किसी ने डाला है, पीआईएल डाला कि पेनफुल है.
जी जी. Right against public hanging. The Rajasthan High Court by an order directed the execution of the death sentence of an accused by hanging at the stadium ground of Jaipur. it was directed that the execution should be done after giving widespread publicity through media. On receipt of the above order, the Supreme Court in Attorney General of India versus Lachma Devi held that the direction for the execution of the death sentence was constitutional and violative of Article 21. It was further made clear that death by public hanging would be a barbaric practice. Although the crime for which the accused has been found guilty was barbaric, it would be a shame on the civilized society to reciprocate the same. The court said a barbaric crime should not have been visited with a barbaric penalty. Right against delayed execution. In TV, Vatisar, Vatiswaram versus State of Tamil Nadu, the Supreme Court held that the delay in execution of a death sentence exceeding 2 years would be sufficient ground to invoke protection under Article 21 and the death sentence be commuted to life imprisonment. The cause of the delay is immaterial. The accused himself may be the cause of the delay. हाँ ये भी बात सही है. The accused himself also may be the cause of delay. He keeps on going, appealing. In Sher Singh versus State of Punjab, the Supreme Court said that prolonged wait for the execution of a death sentence is an unjust, unfair, and unreasonable procedure, and the only way to undo that is through Article 21. But the court held that this could not be taken as a rule of law and applied to each case, and each case should be decided upon its own facts.
तो बार
Procedure
बार कोर्ट
established
में
by
जाओगे
law.
और राष्ट्रपति के पास जाओगे और फिर बोलोगे नहीं मेरे
हाँ
को
हाँ,
नहीं
तो
हुआ
उसमें
ये।
समय बर्बाद होगा ना, जब तक डिसाइड नहीं होगा तो हम खुद अपना डिले करवा रहे हैं उसको. Procedure established by law and Article 21. The expression procedure established by law has been the subject of interpretation in the catena of cases. A survey of these cases revealed that courts in judicial interpretation have analyzed the scope of the expression. The Supreme Court took the view that procedure established by law in Article 21 means procedure prescribed by law as enacted by the state and rejected to equate it with the American due process of law. But in Maneka Gandhi versus Union of India, the Supreme Court observed that the procedure prescribed by law for depriving a person of his life and personal liberty must be right, just, and fair, not arbitrary, fanciful, and oppressive. It also held otherwise that it would be no procedure, and the requirement of Article 21 would not be satisfied. Thus, the procedure established by law has acquired the same significance in India as the due process of law clause in America. ये उस दिन भी पढ़े थे हम लोग सर. Justice V.R. Krishna, speaking in Sunil Batra versus Delhi administration, said, though our constitution has no due process clause, but after Maneka Gandhi's case, the consequence is the same, and as much as Article 21 may be treated as counterpart of their due process clause in in the American Constitution.
ये वही है
ये ये
लिखा
वही है,
देवी,
शेर सिंह.
ये लिस्मा देवी ना,
हाँ, लिचमा देवी.
तो उसको स्टेडियम में टांग दो, उसके वही बोल रहे हैं ना सर जी।
हाँ 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 हाँ,
Publicly
पब्लिक हैंगिंग्स. हाँ, ये वही केस है जो हम लोग पहले पढ़े
was
थे.
passed by Rajasthan. This Supreme Court has taken view that
शेर सिंह वाला अनजस्टिफाइबल डिले इन एग्जीक्यूशन ऑफ डेथ सेंटेंस.
टेस्ट इज प्रोसीजर फेयरनेस हो गया। मुरली देवरा
मुरली देवरा है.
बीड़ी पीने की बात कर रहा है वो।
हम्म.
हाँ ये पढ़ो, ये जरूरी है।
Article 21 on the emergency. ADM Jabalpur versus S. Shukla, popularly known as the habeas corpus case, the Supreme Court held that Article 21 was the sole repository of the right to life and personal liberty. Therefore, if the presidential order suspended the right to move any court to enforce that right under Article 359, the detainee would have no locus standi to a writ petition for challenging the legality of the detention. Hence, such a wide connotation of Article 359 denied the cherished right to personal liberty guaranteed to the citizens. Experience established that during the emergency period of 1975, the people's fundamental freedoms had lost their all meaning, so it must not occur again. The Constitution Act 1978 amended Article 359 to the effect that during the operation of the proclamation of emergency, the remedy for the enforcement of the fundamental rights guaranteed by Article 21 would not be suspended under a presidential order. Given the 44th Amendment 1978, the observations in the above cited judgments are left merely of academic importance.
फिनिश।
थोड़ा जल्दी जल्दी पढ़ा मैं,
ठीक है, नहीं
थोड़ा
ठीक है।
हाई स्पीड में, लेकिन क्या करता मैं इसे?
नहीं नहीं, चलता है। मैंने भी इसको वो किया था बिकॉज बहुत लंबा था वो। नाउ व्हाट इज लेफ्ट, आर्टिकल 21 खत्म हो गया।
जी, इसके बाद तो वो आएगा ना सर,
एक
अपना
मिनट देखते हैं 22 क्या बोलता है। 22 कितना
23, 24, 25, 28 ये सब आएगा।
22 में वो है ना, रिप्रेजेंटेशन की बात करता है। अगर डिले होता है तो छोड़ देते हैं ना डिटेन्यू को।
हाँ, 20 प्रोटेक्शन टू पर्सन्स हु आर अरेस्टेड और डिटेन्ड must be produced before the nearest magistrate within 24 hours, वो सब है उसमें।
22(5) में छोड़ते हैं ना, डिले इन एड्रेसिंग द रिप्रेजेंटेशन, वैसा कुछ करके है। एक मिनट, आर्टिकल ये देखो, ये जरूरी है बिकॉज दिस इज फॉर पब्लिक इंटरेस्ट ना। ऐसा देखो,
डेफिनेटली डेफिनेटली।
दिखाता हूँ मैं आपको, ये बहुत जरूरी है। ये अभी आज नहीं पढ़ेंगे, इसको नेक्स्ट टाइम करेंगे। 22 में
जी हाँ, information, right to consult and defended by a legal practitioner of his choice, the production within a period of 24 hours of arrest before the magistrate।
पब्लिक को मालूम नहीं
ये
पड़ता ना कि भाई क्या है
हाँ
क्या
हाँ
नहीं
हाँ,
है। लेके बैठ जाते हैं, 2 दिन के बाद में प्रोड्यूस करेंगे, तो पब्लिक को कम से कम इसके बाद पब्लिक को मालूम तो पड़ेगा ना कि हाँ उनके राइट क्या है।
बिल्कुल बिल्कुल।
इसमें क्या बोला, एक्सेप्शन क्या है, टू एनी।
Nothing in the clauses 1 and 2 shall apply to any person who for the time being is an enemy alien, or to a person who is arrested or detained under any law providing for preventive detention। ये इम्पोर्टेंट है।
एग्जीक्यूटिव ऑर्डर है ना वो, इसके लिए
हाँ
उसमें
हाँ हाँ।
फिर
No law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months unless an
यहाँ पे
advisory
एडवाइजरी बोर्ड आ
board
जाता है।
consisting
एडवाइजरी
हाँ
बोर्ड एनएसए में किसी को ले
हाँ
लिया,
qualified judges of a high court। हाँ।
3 महीने के अंदर उसको पूरा पूरा कंफर्म करना पड़ता है, अदरवाइज ये तो लीव।
ये इंटरेस्टिंग है, ये बहुत जरूरी है, क्योंकि ये पुलिस वाले बहुत परेशान करते हैं सबको।
ये देखो,
Unless a person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order shall as soon as be communicate to such person the grounds on which the order has been made, and shall afford him the earliest opportunity of making a representation against the order।
now if you have detained somebody and not served him the ground, then he is unable to represent na।
No, what has, I mean, what charges have been leveled against him?
he should know ना। एट द इसमें क्या
Definitely
है,
sir।
सुप्रीम कोर्ट ने जजमेंट दिया कि 5 दिन का टाइम देना चाहिए नॉर्मली। सपोज somebody does not understand the language in which the detention ground of detention are passed, तो उसको ट्रांसलेट करना पड़ता है ना एक बार उस लैंग्वेज
जी,
में। फिर
and in the language in which the detainee understands।
हाँ, तो इसके लिए थोड़ा सा उसको एक मतलब टाइम दिया है कि ग्राउंड ऑफ डिटेंशन पास करने में, अब बाद में उसका ट्रांसलेट करने में उनको टाइम लग सकता है। अब ये सिर्फ क्या बोल रहे हैं,
6 बोल रहा, nothing in clause 5 shall require the authority making any such order as is referred to in that clause to disclose facts which such authority considers to be against the public interest to disclose।
ये नहीं क्यों तुमने मना किया था ये उसके बाद।
हाँ,
मतलब कुछ चीजें ऐसी होती है ना जिसको बताना नहीं होता पब्लिक इंटरेस्ट के लिए, तो वो नहीं बताएगा ग्राउंड ऑफ डिटेंशन में। ये
circumstances and the class or classes
किसको
of
किसको
cases।
डिटेन करना है, अब जैसे ये आया था ना, जम्मू कश्मीर वालों को उठा लिया था।
हाँ हाँ हाँ, period longer than 3 months। may be detained for a period longer than 3 months under any law providing for preventive detention without obtaining the opinion of an advisory board in accordance with the provisions of subclause A of clause 4.
हम्म,
ये स्पेशल केसेस में, हाँ, the maximum period for which a person, अच्छा, maximum period वो बताना होगा, procedure to be followed by the advisory board in an inquiry.
हम्म। तो दिस विल डिस्कस इन द नेक्स्ट एपिसोड।
जी सर।
अभी इसको बंद करते हैं, ठीक है। थैंक्स फॉर
जी
टेकिंग
सर।
द पेन ऑफ
नो
रीडिंग।
प्रॉब्लम एट ऑल सर, माय प्लेजर सर, ऐसा मत बोलिए सर, इट्स माय प्लेजर, you have given me space in this your august platform.
आई एम गिविंग यू, क्या बोलते हैं, होमवर्क। यू आर रिप्रेसिंग द कॉन्स्टिट्यूशन लाइक, और क्या
नहीं,
है
बोलिए
ना।
सर क्या करना होगा।
नहीं, मैं यही बोल रहा हूँ कि आई एम गिविंग द होमवर्क
नहीं
टू
नहीं, ये
टू
मेरे
रीड द
लिए तो फायदा ही है ना,
कॉन्स्टिट्यूशन। आता होगा पढ़ लो,
आई एम
बिकॉज यू आर वर्किंग।
रिकैपिचुलेटिंग सर,
मैं तो
आई एम
यहाँ पे बैठे आई विल
रिकैपिचुलेटिंग
बी।
बिकॉज ऑफ यू। नहीं, आई एम recapitulating things because of you, otherwise probably I wouldn't have, I mean, taken the trouble. So thanks to you sir, again and again, for affording me this wonderful opportunity.
तो
It's always a pleasure to be with you sir.
अगर पब्लिक को ये अच्छा लगा हो तो इसको थोड़ा सा अपने दोस्तों यारों के बीच में सर्कुलेट करो, लाइक करो, जिससे कि ये काफी दूर तक पहुंच जाए। आज नहीं, कल नहीं, परसों कम से कम जो
नहीं,
बच्चे,
काम तो आएगा ही है।
हाँ, सोसाइटी में है।
अब जहाँ फिर सर बोल दीजिए, कहीं कहीं लीगल पार्लेंस में प्रॉब्लम आए किसी को, तो दे कैन ऑलवेज आस्क, वी विल एक्सप्लेन इन लेमैन टर्म्स।
और मैं पेरेंट्स से, बड़े भाइयों से, बड़ी बहनों से और माताओं से रिक्वेस्ट करता हूं कि अपने बच्चों को इस वेबसाइट, इस यूट्यूब में चैनल में आने को थोड़ा सा प्रेरित करें, इंस्टीड ऑफ देम वेस्टिंग देयर प्रेशियस 8-9 आवर्स इन एक्स मुस्लिम चैनल, जहाँ पे बैठ करके वो लोग कुछ नहीं देखते हैं, सिर्फ फेनेटिक बनते हैं, फंडामेंटलिस्ट बनते हैं। वहां से थोड़ा सा हटवाओ उनको, इधर आने को बोलो। हम लोग यहाँ पर आप लोगों की, मतलब क्या बोलते हैं, उसके फ्री में सेवा कर रहे हैं। और हम तो ये सोचते हैं कि अगर हमारा एक कदम पॉजिटिव होगा तो बाद में कम से कम करोड़ों कदम पॉजिटिव चलेंगे। हम तो इस बात को सोच के चलते हैं। यहाँ पर किसी के कोई वो नहीं है हमारे को कि भाई हमें सपोर्ट कर दो, हमें सुपर चैट दे दो और ये दे दो वो दे दो। आपकी मर्जी है, आप सपोर्ट करना चाहें तो करें, नहीं सपोर्ट करना है तो कोई कंपल्सन नहीं है। हम ये सेवा करते रहेंगे जब तक हमारी सांस रहेगी,
बिल्कुल सर, बिल्कुल सर।
या जब तक हमारे हाथ पैर चलते रहेंगे तब तक, ठीक है। तो फिर से एडवोकेट लर्नेड मजूमदार साहब को नमस्कार,
सर,
धन्यवाद।
थैंक यू वेरी मच सर, थैंक यू सर।
ओके, बंद
You
करते
are more senior to me and more learned, sir.
हैं, बंद करते हैं इसको।